And then at this point of the meeting, I will be turning over the meeting, and I have recused myself from this item because I do a lot of work up in the Hermit's Peak Calf Canyon area in my professional work. So I will be turning over the meeting to Vice Chair Trujillo Davis and Ms. Orth at the appropriate time. And I appreciate everybody's attendance and also on the platform as well. And good luck. Thank you.
Okay, thank you, Chair Swina. Well, let's go ahead and move on to item 6, the public hearing for EIB 2451, Acequia de Alto y Los Martinez and Rowan Stanland versus PG Enterprises LLC, and EIB 24-51, Sinclair versus PG Enterprises LLC Consolidated. At this point, I think I can turn it over to you. Okay.
You can. Good morning. My name is Felicia Orth, a hearing officer appointed by the Environmental Improvement Board to conduct a hearing in the matter of the consolidated relocation permit appeals for permit NSR relocation RE058661. That's PG Enterprises. The petitioners include Acequia de Alto y Los Martinez and Rowan Stanland and Fiona Sinclair. These appeals were docketed as EIB numbers 24-51 and 24-52, and then consolidated for the purpose of having one hearing. We have a number of petitioners, as I said, and others who entered their appearance. This is Dr. Sinclair, Ms. Andrea La Cruz Crawford, Rowan Stanland, Nicholas Maxwell, John Block, Henry Sanchez, and of course the Air Quality Bureau of the New Mexico Environment Department. The hearing will be conducted under the Air Quality Act and the board's own adjudicatory procedures, which can be found at 20.1.2 of the New Mexico Administrative Code. Comments and technical testimony are taken under oath, subject to cross-examination. The rules call for the petitioners to go first and for others to follow. We will take the statements in whatever sensible order is proposed. There's some question raised about whether the board gave proper notice in order to be able to deliberate in the event we close the record today, which I expect we will do. But let's have that discussion after the close of the record. The board may have to set up another meeting to deliberate. So let me take appearances now. Ms. La Cruz Crawford? Oh, hear me? Yes. Okay, thank you. And let's see, Mr. Vigil or Mr. Hirsch?
This is Chris Vigil, New Mexico Environment Department, here with Josh Hirsch.
Okay, thank you. Let's see, do we have Dr. Sinclair? Hello. Rowan Stanland? Okay, thank you. Mr. Maxwell, I see you on the platform. Thank you. Mr. Block?
Yes, I'm here. Can you hear me? I'm not sure I'm connected.
You're pretty soft.
Can you hear me now?
Okay, I can hear you. It's still soft. When we come to your statement, I may ask you to lean into the mic a little more, but I see you.
Okay, you do see me. Okay, because
Thank you.
I have no indication that I'm there. Yeah.
Okay, and that last sentence was very clear. Thank you.
Okay.
Mr. Sanchez? Okay, thank you. Terrific. And I managed to forget to say that the hearing is being transcribed by David Lee of Cumbre Reporting, and there is also simultaneous interpretation between Spanish and English and Spanish by Lisa O'Grady and her team of interpreters. Ms. O'Grady, would you please make a statement for those in attendance?
Yes, good morning. For those who are here present, there are headphones where you can access the simultaneous interpretation. So if you do want to listen to the interpretation, please come forward and I'll give you a headset that you can put on. For those of you who are on the platform, you'll need to choose your language. At the bottom left-hand corner of your screen, there's a globe. Just click on the globe and then you'll see English or Spanish. Please choose the language that you prefer. And if you are hearing both languages, slide the bar over to interpreter and then you will not hear the English. Buenos días para los que están aquí presentes en la sala de audiencias. Si hay alguien que quiere escuchar en español, por favor pasen adelante y con mucho gusto le entrego los equipos, los auriculares, para que puedan escuchar en español. Para los que están en la plataforma, ustedes nada más necesitan buscar en la esquina inferior a la izquierda y ahí van a encontrar el mundo. Nada más háganle clic en el mundo y luego pueden escoger su idioma. Si escogen español y todavía están escuchando en inglés, nada más necesitan deslizar la bolita hasta la derecha y así solamente van a escuchar el español.
Thank you very much, Ms. O'Grady. Let's start with opening statements. Ms. La Cruz Crawford, please.
Sure. First of all, thank you for having me here today. I appreciate your time. I'm glad that you have provided the opportunity for us to be here today. On May 20th of
That's fine.
Feed.
All right. Oh, I can hear myself now. Also, I'll just apologize. I cannot hear very well today myself. I'm just very congested. So I may have to ask for clarification and I apologize ahead of time. Okay. On May 20th, it is cutting out. Hold on, let me try and get it to work. Okay, on May 20th, 2020, permittee, is there a way to fix this? Directional? Okay, I'll stay right here. Okay, that might be easier. I'll just use this and I'll stay in one direction. Okay, so on May 20th, 2020, the permittee PGE was issued a regular news source review permit by the Air Quality Bureau for a facility located in Rio Rancho, New Mexico. Thereafter, it's notable that on June 21st, 2024, a separate entity named Rancho Escondido, which is a business owned and operated by Salomon Olivas, the owner of the property at issue in this permit, applied for a general construction permit from the Air Quality Bureau for the same site where the crusher is located under this relocation permit. On July 19th, 2024, that permit application was denied by the Air Quality Bureau. And I want to note that the language of that denial specifically provided 30 days to appeal the department's action or that the decision of the department shall be final. We note that this application was for aggregate materials and crushing at the exact same location as the location in this permit. On August 1st, 2024, about 2 weeks after that denial, PGE filed the present NSR relocation application with the Bureau, which sought to move the location of their Rio Rancho-based NSR permit 8661 to the same site where the Bureau, only 2 weeks earlier, denied the permit application by Rancho Escondido. The NSR relocation permit by PGE was granted by the Bureau on August 16th, 2024. The Acequia Alto y Las Martinas submitted objections and has standing based on the fact that it holds an easement through the site directly adjacent to the crusher, where it not only conducts spring maintenance and enters onto the property after every rain event.
Objection. This is testimony. It's not an opening statement. I will not continue to object, but I would like to just put on the record a continuing objection to the extent that the attorney is entering testimony. Thank you.
All right, thank you, Mr. Vigil. Ms. Crawford, as you know, the opening statement is meant to orient the board to say what your evidence will show and to address that fairly at a fairly high level. But please go ahead.
Okay. The evidence will show that the Acequia serves members who irrigate crops, water livestock, and they do so from the spring through the fall of each year. Despite the decision of the Bureau to permit this application pursuant to the New Mexico Administrative Code and existing requirements for this permit, the EIB must reject this application to relocate permit 8661 at this particular location for the following reasons. 1, the permit issued to PGE acts to circumvent the binding decision of the Air Quality Bureau, which denied the landowner through his business Rancho Escondido a general construction permit at the same exact location and should be summarily denied, especially because aggregates are clearly being produced at the facility, as the testimony will show today. PGE as the responsible party for this site, 2, PGE is the responsible party for the site, must manage the site conditions surrounding the crusher. Testimony will establish that PGE has failed to ensure that legal requirements for operations in general at this facility are met, pertaining to dust suppression and record keeping of emissions, and to exercise proper management and control over the site where the crusher is located. Testimony will show the landowner and his business, Rancho Escondido and Olivas Trucking, are still actively involved in site operations, despite the fact that they do not have a permit from the Bureau and were not listed on this permit application. Further, testimony will establish that Mora County has issued a notice to cease operations to the landowner. The Bureau will argue that this operation of other entities on site is not pertinent to your consideration of this air quality permit. And you should consider this appeal in a vacuum where there is no tie between the people hauling materials from the site and the entity holding the permit, where there is no connection between particulate matter from the crusher and the acequia a few steps away, and where an existing permit purchased from an outside entity like PGE is being used to circumvent a legally binding process for obtaining permits. 3, there is widespread community opposition to this operation at this particular site. Evidence that was submitted into the record by pro se party Rowan Stanland indicates there are around 116 signatures from community members and businesses opposing this facility and its operations. 4, the Bureau has erred in its assessment of the applicable setbacks because it has an obligation to consider the real-world impacts of the relocation on local residents and not to simply take a setback developed for a very different site location at face value. The intent of the regulations is to ensure public safety with regard to particulate matter from the crusher. Testimony provided today will show that this branch of the acequia, which has 2 branches, serves about 80 families and is used to irrigate crops that are consumed and to water livestock. Testimony on the record will show that the acequia is located only a stone's throw away from the actual location of the crusher. The relevant language contained at permit condition A114E requires that relocation of an existing permit is not permitted where the plant, which is defined as the perimeter of the area of operations inclusive of all disturbed lands, including mining and overburden removal areas used for the job, is to be relocated within any city or town boundaries and was not initially reviewed for these conditions. It also says that it shall not be permitted if the plant is within a quarter mile of a private residence or an occupied structure. The Bureau takes the 67-meter setback from the crusher to the nearest fence line at face value and ignores both that the plant, as defined by the permit itself, is located less than 1/4 mile from an occupied structure based on the existence of the facility annex, which we will provide testimony to explain today. It's also located within the town of Cleveland, a site condition that was not considered. The relevant language of the permit is contained in the administrative record at pages 172 to 173. All of this after residents already fought and prevailed against a permit that was sought by Rancho Escondido for the same type of operations at the same site. Regardless of the specific setback for relocation in the permit, the Bureau should have considered this application for its actual impacts on nearby residents and existing water supplies as well. And failure to consider these impacts was not consistent with the Bureau's requirement to protect public health and welfare, or the court's decision in Colonial Development Council versus Rhino. In the Colonial Development Council versus Rhino case, the New Mexico Supreme Court mandated that NMED must consider non-technical testimony, such as social, cultural, and quality of life impacts expressed by members of the community. The testimony today will highlight the severity of those public concerns and the associated public outcry against this facility. NMED also has obligations under Title VI of the Civil Rights Act of 1964, which provides the department shall not use criteria or methods of administering its program which have the effect of subjecting individuals to discrimination because of their race, color, national origin, or sex, or have the effect of defeating or substantially impairing accomplishment of the objectives of the program. The location for this relocation permit is in a predominantly Hispanic, poor, underserved community that is primarily Spanish speaking. It is also a declared federal disaster area that recently received state monies for fire hazard and flood mitigation after the Calf Canyon fires because it is in the burn scar. NMED is legally bound to consider all environmental impacts of this facility, not just air pollution, and thus determine whether there will be any disparate impact on minority populations. While we appreciate the recent addition of permit condition number 9, which does not allow crushing when the acequia is conducting maintenance, testimony today will establish that maintenance occurs continuously between the spring and fall of each year. This permit condition does not account for the fact that the water from the acequia is used for livestock as well in the winter months. For these reasons, no crushing should be permitted within 67 meters of the acequia. Point number 5, and I'll be summing up shortly. The relocation permit also fails to address other differing site conditions at the new location from those conditions that were addressed in the original NSR permit. Importantly, as we have noted already, this is in a federally recognized disaster zone and FEMA floodplain with an increased risk of flooding and contamination through drainage from this facility. The Bureau should add a permit condition that states that the permit will be revoked if the permittee fails to comply with any municipal, county, state, or federal permitting requirements for the site. B, there is an acequia operating just feet from the crusher, as testimony will show, and multiple waterways are impacted by the outfall of particulate from the crusher, and including as well as the well for the mutual domestic drinking water supply, which serves residents of Cleveland, which is also detrimentally impacted and located only a 1/10 of a mile from the plant. These are specific site conditions that did not exist at the Rio Rancho facility. NMED needs to address this permit holistically by reassessing the new site conditions and considering existing surface water standards and the impacts of particulate matter entering into the acequia from the crusher, given its current location. In sum, the Bureau is obligated to consider and address the direct impacts of this permit and how it will affect local residents, regardless of the setback requirements established by the original permit for the Rio Rancho facility. Finally, and just briefly, we note that the notice of the application for relocation permit was posted on a standard 11 by 17 sheet of printer paper along a public roadway where vehicles travel at high speed. The small font size of that notice, as well as the lack of large text that could be seen by passing vehicles, was not sufficient, in our opinion, to reasonably apprise the public of the existence of the application, and therefore fails to adhere to procedural standards for due process. Thank you. And without further ado, I turn it over.
Thank you, Ms. LaCruz Crawford. Let me ask if the other petitioners, and I'll go one at a time, would like to offer an opening statement. You can offer one or not. It's not required. You can say that you agree with the points made by Ms. LaCruz Crawford, but I'll call on you one at a time. Dr. Sinclair, do you have an opening statement? Oh, I'm sorry. Okay. All right. Thank you. Thank you. Dr. Sinclair. All right. Thank you. Let's see. Ms. Stanlin?
They can't hear on the platform.
Okay.
Thank you.
Hello. Andrea's mic is cutting off like every 5 words. It was very, very difficult to hear her. Is there anything we can do? I agree with everything she said, and I have no further comments. Thank you.
All right. Thank you, Ms. Stanlin. Let me see. Mr. Vigil, is it possible that the mic in front of you would be better?
Is this better?
Oh, yeah.
Yeah, what I think, it seems to me that like you got to be right on the mic and maybe not too. So it seems like it cuts out if we get too close and cuts out if we're too far. So it's got to kind of like.
Okay.
It's a delicate dance, I think.
All right.
And I might just ask if there is a mic over there as we move forward. I don't know if there's just another spot I could move to, if I could have permission to do that.
You may absolutely move to that corner of the dais. In fact, we often invite folks who are coming up from the seats to make public comment to join us at one end of the dais as well. All right. Let's see. So Dr. Sinclair and Ms. Stanlin both said they did not have their own opening statements. They support Ms. LaCruz Crawford's. Mr. Maxwell?
I think this is working now. It was charged. It just wasn't turned on. So,
That's fine. Mr. Maxwell, on the platform, do you have an opening statement? Thank you. Mr. Block?
No, I concur with Ms. LaCruz Crawford's comments, and I have no need for an opening statement.
Thank you. Mr. Sanchez?
Not here yet.
All right. So would you give us your name, sir?
My name is Ed Martinez.
Okay, so Mr. Martinez has confirmed that Mr. Sanchez is not yet with us and that he is aware that Mr. Sanchez would be supportive of Ms. LaCruz Crawford's opening statement and would not have one of his own. So now we turn to the department. Mr. Vigil.
Chris Vigil, New Mexico Environment Department. Madam Hearing Officer, Madam Chair, members of the board, Madam Vice Chair. The department is here today to provide technical testimony and rebuttal testimony in support of the recommendation to amend and uphold the department's decision to approve the relocation of PG Enterprises aggregate processing facility, which was issued in accordance with the Air Quality Control Act and associated state and federal regulations for issuing air quality construction permits. Based on the only legitimate challenge brought by the opposing parties, the department has amended its approval letter by adding condition number 9, which would prohibit the operation of the facility at any time when SECUA improvements or cleaning are taking place within the boundaries of the property. We have submitted to the board and to the other parties proposed amendment letter as NMED Exhibit 6. And so the department is here today to ask the board to amend the approval based on NMED Exhibit 6. The department will offer testimony explaining the basis for the amended approval. The challenges that the opposing parties have brought in this matter do not provide the board a reasonable basis for reversal of the department's decision in this matter, even without the amended approval letter. The opposing parties provided no legal base on which the board could deny the challenge, deny the approval. The opposing parties have brought various challenges that are outside the scope of both the department and the board's jurisdiction. The opposing parties would like this to be a mining case, but it is not. They would like it to be a property law or nuisance case, but it is not. They would even like it to be an issue of historic preservation, but it is not. This is an air quality permitting case and one in which PG Enterprises and the department followed the law. As is often the case in these matters, the opposing parties would like to turn this into a de facto rulemaking in which they're asking the board to go outside the scope of its authority in order to adopt rules that, while maybe legal, maybe even preferable if adopted through the normal rulemaking process, ignore the due process elements that are required for all of New Mexico citizens, including the department, in order to enact new rules. Petitioners offer Mustafa Chudnoff as an expert witness. Mr. Chudnoff's resume shows nothing to indicate that he has any experience in air permitting or knowledge regarding the source relocations under the Air Quality Control Act or the federal and state regulations. Instead, petitioner's apparent intention is to try to turn this into a groundwater or mining proceeding, but it is not a groundwater or mining case. Petitioners are offering Mr. Chudnoff to give testimony on statutory easements, but he's not an attorney. He intends to give testimony on who should be included on the permit application, but again, he has no experience in air quality permitting. Similarly, Ms. Stanlin, Mr. Sanchez, Mr. Block, and Dr. Sinclair intend to present testimony, some of which is technical in nature, but provided no resumes that would allow the department to assess their fitness as technical witnesses. Not one of the opposing parties' witnesses appear to have any experience in air quality permitting. The department will offer qualified technical witnesses who have over 50 years of combined experience in air quality matters and who have worked on hundreds of air quality permits. Their testimony will show that the Air Quality Bureau gave a thorough and complete administrative and technical review of the relocation application that ensured that the relocation meets all the legal and technical requirements under the Air Quality Control Act and associated regulations and is protective of human health and the environment. This is especially so in light of the proposed amended approval letter. In addition, the department will offer Soliman Olivas, the co-owner of the property and a Acequia commissioner, to explain how the ditches are cleaned, maintained, and how members of the public are prohibited from recreating in the Acequia on the property. The department is here today to respectfully request that the board amend and uphold the department's decision to approve the relocation in accordance with NMED Exhibit 6. Thank you.
Thank you, Mr. Vigel. Ms. LaCruz Crawford, I am looking at your NOI, the Notice of Intent to Present Testimony. I see you identified Mr. Chudnoff, Ms. Stanlin, Mr. Martinez, Mr. Sanchez, and I'm wondering, is that the order in which you would like to present the testimony?
I believe I'd like to take the non-expert testimony first. So I'd like to start with Rowan Stanland, and then go to Ed, and then Mr. Sanchez, assuming he's present at that time, and then my expert at the end. And I would like to request that I'd like to limit the scope of the direct so that I can allow some time for rebuttal. Or Mr. Chudnoff after the Bureau's experts have gone.
Yeah, that's fine. I believe Mr. Chudnoff's narrative testimony was in your Exhibit 10.
Yes,
and
that's
the board has that in hand.
Okay, thank you.
Fine. So let's see here.
May I volunteer the witness, please?
Oh, she's not being offered as a technical witness, I don't believe, Mr. Vigel.
She was disclosed in the technical disclosure because I had noticed that you had disclosed Solomon as a technical witness. So I just wanted to make sure that I had listed each of my witnesses, but she will not be providing any technical testimony today.
Right. I'd like you to save your questions for
Well,
cross-examination.
we have not seen her testimony, and the documents that were provided are highly technical in nature. And so maybe we could start with exhibits. We do have objections to the page 52 to 56 of Ms. Stanlin's testimony disclosure, which is and page 65, with a caveat that if Ms. Stanlin can provide a foundation, essentially these are technical documents, and there's no way of assessing what her credentials are to testify in that regard. And essentially, she is going to be testifying on permitting matters and why the permit doesn't meet the legal standards. So that is technical testimony.
Okay. Ms. LaCruz Crawford, you may know that in these proceedings, in fact, opining about what the law is or does not require is considered technical testimony. I mean, it's not engineering or chemistry, but it's considered technical testimony because it requires education and expertise.
And actually, what I do have an alternate potential way of handling this, because I do know that Ms. Stanlin made a request prior to this hearing that she be permitted to provide her own statement on the record. So one thing that I would be open to is if we want to let her just go first and providing her own statement, and then we can just cross-examine her. That may expedite the entire matter as well.
Okay, and Mr. Behill, I would prefer to take up the question of what is in the exhibits and what your objections might be when the exhibit is actually offered and we know whether a foundation has been laid, and let's have that conversation a little later.
Yes, yes. And I will take your final answer as a final answer, but I'd like to renew my request of voir dire the witness because, again, there will be touching on historic preservation. There's no way of knowing that Ms. Stanley has any knowledge or education, training whatsoever to be, giving historic preservation testimony, air quality testimony. And it appears to me that their attorney is saying that, well, we can get around the requirements to lay a foundation if I'm not involved. But again, Miss Stanlin's appearing as a party and a witness. It's unorthodox. If I wanted to be hard about it, I guess I could have opposed it. We're trying to be as open as possible. But I do think that we need to bring some order to this proceeding. And, there are rules here. The people of New Mexico and the Environment Department, we have to have a level playing field. And this idea that we're going to switch now, I guess what it is Miss Stanlin's now going to go first, and that's okay. But it seems like it's an attempt to get around the requirements to have some kind of technical proficiency. So I renew my request, and I'll take your final answer.
So my final answer is the same as what I said a few minutes ago. I would like you to save your questions for cross-examination. And in the event any witness, including a department witness, provides testimony that I believe the board should not rely upon in making its decision because it is not sufficiently reliable, for example, based on a person's education or expertise, I'll have an opportunity to point that out. But I'd like to proceed through the comment, the testimony, and we can have another conversation about the sort of substantial evidence the board needs in order to reach a decision. So, Ms. Stanlin, do you swear or affirm that the testimony you're about to give will be the truth?
Yes.
Okay. Thank you very much. Go ahead.
I am hoping to show the exhibits if I am allowed to screen share. And I apologize, I've never done anything like this, and I'm trying to Rowan Stanland.
Ms. Jones is going to give you permission to share your screen. It just takes a moment.
Okay, so how do I open something? How do you see my screen?
Effects?
Yes, I'm on here. Okay, thank you.
I'm also having look at it on what the platform.
Okay. All right. So this is on. Thank you. Good morning, everyone. We are very grateful for this opportunity to speak on this issue. Thank you. We respectfully ask that this permit is repealed. In the initial scheduling meeting for this appeal, the first thing that Mr. Vigil said was that he would move to deny before even having it heard before the board. Unfortunately, this sentiment appears to be standard practice for NMED. When we started this journey back in April of last year, we sincerely thought that it was so obvious that this was the wrong place for a gravel quarry that NMED would surely deny it. And they did. On July 19th, the Air Quality Bureau denied Rancho Escondido's GCP2 denied the Rancho Escondido GCP2 application because the setback was not met. The quarry is too close to people's homes. Within 2 weeks, a new public notice appeared at the quarry for an NSR relocation permit, the ultimate NMED loophole. The NSR eliminates the setback and doesn't even require specific air modeling for the site. Our assumption was that the environment would be considered in this process and that community voices would be considered in this process. We were wrong. We ask that the board hear us because NMED has not. We live in the historic farming village of Cleveland, New Mexico. This is home to the famous Cleveland Roller Mill Museum. This is a photo that I put up first. The mill was built in the late 1880s and operated until the 1940s as one of 3 local flour mills operational at this time. The Mora Valley was known as the bread basket of New Mexico because of its prolific wheat production and vibrant acequia and farming culture. The mill is a museum today and operates every year on Labor Day weekend for the Mill Fest. It is the only mill of the era that is still operational, thanks to decades of effort by the Cassidy family. The museum is open to the public every weekend and in the summer for a tour of the 3-story adobe building and a year-round photo exhibit. So I'll just continue with the photos here. Thank you. The Cleveland Roller Mill is less than 1/2 mile from the quarry. This is Collins Lake, which is within 1 mile of the quarry. This is Hummingbird Branch, which is also within 1 mile of the quarry. It's Hummingbird Ranch also, and just a shot of what the Mora Valley looks like. Mora Valley is rich with surface water and has many centuries old farming communities. The Rio La Casa and the Mora River both run within 1/2 mile of the quarry. On the north side of the quarry is the historic Cleveland Roller Mill, the Cleveland Post Office, and the Cleveland Mutual Domestic Well, all within 1/2 mile. On the south side of the quarry is Pendleton Propane and the historic Mora Inn within 1/2 mile. On the west side of the quarry is Collins Lake and Autism Center and the Hummingbird Ranch community within 1 mile. On the east side of the quarry is the Cleveland Roller Mill within 1/2 mile. There are 4 buildings on the historic register within 1/2 mile of this quarry and many more that would qualify. We are situated in a precious ecological area and an area rich in cultural and historical significance. We are truly blessed to live here. Just an overview of the maps. If you can see my cursor on here, but Collins Lake is located in the top left of the quarry. The Cleveland Roller Mill is here within 1/2 mile on the bottom right. The village of Cleveland is here, just north. And I wanted to put this map up also that shows where the mutual domestic wells are. So this is in the village of Cleveland. This, where I'm circling here, is the, I can make it bigger. No. This is the Cleveland Mutual Domestic, just north. And just south, where this blue star is here, is the Mora Mutual Domestic. And these are wells that serve for the water supply for the entire valley. Just need to put up one photo. Okay, so this photo, the bottom right is the Mora Inn, which is the only, is that working? No, it didn't come up. The screen share just kind of froze, I guess. I changed the image, but it didn't change on the screen.
Is it in a different document?
Yeah.
So you're gonna have to stop sharing.
Oh. So I can cancel out of that. How do I and get rid of that?
So
Okay, so this is the on the bottom right with the red roof is the Mora Historic Inn. This is Pendleton Propane on the just above it, also with kind of a red roof. So this is the community of Cordillera, which is on the south side. And this just on the north side is the community of Cleveland. So you can see how close it is to our community. Okay, so I'll continue.
thank you. So don't do anything. Isn't it? Sharing. Then cancel.
Okay, thank you. I apologize. All right. The residents of Mora take pride in being stewards of the land, and their livelihood has always depended on this environment. Unfortunately, now we are faced with landowners that instead prefer to destroy their land for short-term profit. The landowners created this quarry without consideration of the community that surrounds it. Not only have they disregarded their neighbors, but they have disregarded the law. In November of last year, Mora County issued a cease and desist letter for Rancho Escondido for operating without a business license. And this is what I have up on the screen here. Mora County also requires a conditional use permit, which they also do not have. In fact, Mora County has a sand and gravel ordinance, which prohibits a quarry at this location. The quarry area is within 10 feet of the acequia, as Andrea had mentioned earlier. According to the EPA Region 6 Construction General Permit Coordinator, they are operating without a stormwater pollution prevention plan. This is the email from the CGP coordinator for Region 6. According to the Office of the State Engineer, they have not reported any meter readings for the well permit that they were issued last July. The OSC reported they have no record of the well at all, although they are still able to grant a well permit. Presumably, this well doesn't exist. And this is the email from the OSC from Catherine Berenson. According to the Air Quality Bureau, they have not submitted any air monitoring records or logs required by this permit, yet they continue to operate. And this is the email from the IPRA coordinator, Morgan Hibbert, that shows that there's no records for air quality. According to Rhonda Romero, the permit they had for a concrete plant years ago was terminated due to lack of payment. There has already been a car accident at the quarry entrance on Highway 518 because of trucks pulling out, and they had no DOT driveway permit. On December 26th, they submitted a technical revision for this permit. We can only speculate what the reason for this would be. Perhaps because the equipment that they have on site is not actually the equipment that is required or listed by the permit.
I'm sorry? Why?
On December 26th, PG Enterprises submitted a technical revision for this permit. We can only speculate that the reason they are asking to revise is because the equipment they are currently using at the quarry is not actually the equipment listed on the permit.
And sir, what is your name? Okay, thank you. We just need it for the transcript. All right. Go ahead, Ms. Sandlin, and remember that we have both a court reporter and Spanish language interpreters who are trying to catch your every word.
Thank you.
So just avoid speeding up.
Thank you for that. Our community has been reaching out to NMED since last April when we first learned of the quarry. There was one single 8.5 by 11 sheet of paper stapled to a tree at the entrance. This was the public notice, and it was nearly impossible to see. One would think for an operation of this magnitude that a 2 by 3 yellow foot sign would be required, like any other construction site. But it wasn't, just a single sheet of paper. NMED doesn't require notice to be posted at the post office or even a single letter to be mailed to the closest neighbors. This policy is a failure of public notice. Nonetheless, the community gathered against the quarry. An online petition was created and garnered over 115 signatures. There's actually over 120 now, overwhelmingly by the residents of Cleveland. A paper petition was located at the Mora Inn, which received another 15 signatures. Signatures include the owner of Pendleton Propane, the owner of Collins Lake Autism Center,
Slow down.
and the owner, a co-owner of the Mora Valley Ranch store, who is here with us today, Mr. John Block. The public comment process with NMED garnered more than 25 letters of objection. One letter from a neighbor who has respiratory issues. Another from a neighbor that is concerned that this location is in a FEMA flood zone and we're coming out of a terrible fire. Another neighbor who lives directly across the street, or across the highway, excuse me, who shares a story about her horse that almost drowned after the fire when the flood waters from the Mora River came all the way up to the horse's head. Her concern is what happens during the next flood now that this quarry is here. So this is the petition and the signatures that we have. Overwhelmed. Sure. Over. But he asked for, thank you. He asked for a copy of the petition and we're happy to provide that.
Okay. Every document in this matter that has been filed to date, including those filed yesterday, can be found on the board's Docketed Matters webpage. And Ms. Jones, behind me, the board administrator, can certainly help you locate that. She may even have a hard copy handy, otherwise it's on the webpage. So go ahead, Ms. Stanland.
Thank you. I'm just going to quickly scroll down through it. The overwhelming majority of the signatures on this petition are from Cleveland. And this is the paper copy that we had at the Mora Inn. And this is the list of letters that were received by NMED in opposition to this permit. And this does not even include any of my letters and only one of Dr. Sinclair's, and this is over 25. And I did include all of these letters, and this is like a 50-page document, so we're gonna just skip it. We'll move on to the next thing. Oh, okay. But all those letters were submitted in my exhibit list, so they're available to see. The closest neighbor to the quarry are the Davidsons. Their house is within 25 feet of the fence line of the maintenance yard of this quarry. They opted against testimony today in hopes of avoiding continued harassment from the maintenance yard, which is directly outside the front window of their house. While out of town over the holidays, Paula Jean house sat for them. Her written statement indicates truck noise audible from inside of their house. And she says that there was so much dust in the sky that it clouded the sky. Excuse me, there was so much dust in the air that it clouded the sky. The air quality in our area has been significantly degraded since the fire because we are now living in a burn scar. This has caused respiratory issues for some people. My understanding of her statement is that the barren landscape in the burn scar, in conjunction with the barren landscape the gravel quarry has created, that there is so much dust in the air that it is causing them to cough. The impact to the Davidsons is unimaginable. The quarry has destroyed their privacy, their peace and quiet, and their property value. Paula filed an air quality complaint with NMED and explains in her statement.
Objection, hearsay.
All right. Thank you, Mr. Vigil. I'll give you a continuing objection as to hearsay here. Go ahead, Ms. Stanland.
The letter is here. Would it be better if I read the letter instead of summarizing the letter, or how do you want me to continue?
No, I think that letter is already part of your exhibits. Is that correct?
Yes.
That's fine. You need only refer to it. It's available to the board for their consideration.
Okay, thank you. So I'll just continue to summarize. Paula filed an air quality complaint with NMED and explains in her statement how ineffectual the process is. While Mr. Spillers from NMED did reply to her complaint, he explains that he has little authority. There have been several air quality complaints, and he came to Mora to investigate. He said that he couldn't go into the quarry without permission from the permittee and that he had not heard back from anyone to make an appointment. But to his credit, he did come up and attempt to visit, although he couldn't enter. He stopped at Pendleton Propane, where they reported unusual amounts of dust and noise inside the office. Statement is here. I will continue. The lack of NMED oversight in this process has been discouraging. NMED has failed to acknowledge the HPCC fire and subsequent emergency declaration whatsoever. In 2005, Supreme Court ruling Colonius versus Rhino requires that NMED consider.
Objection. Ms. Stanley's not an attorney. She's testifying about a legal case.
Ms. Allen, what is your point here when you are talking about the law?
I'm sorry, can I just really briefly just mention, first of all, I do not represent Ms. Stanley. I wanted to correct that at the initiation of this. She is a pro se party. And my understanding of the law is that pro se parties are afforded the same rights as attorneys and represent themselves as self-represented parties and can present legal argument that's based on case law.
So they can present argument again without speaking as an expert on that law. They can certainly advocate for themselves.
Madam Hearing Officer, I
Mr. Beal.
I have to say I am a little unclear about what's happening here. Now, she says that she doesn't represent Ms. Stanley, but she was going to directly examine Ms. Stanley. So, which indicates to me that she is being offered as a witness. Now, in order to circumvent the rules about expert or technical testimony, Ms. Stanley then became an independent party. And I understand that's fine that she entered an appearance. I don't have a problem. But now that I've objected to the fact that she is a non-attorney who appears to be giving highly technical testimony, which would, be interpreting a legal case, we were not allowed to voir dire, which is fine. We can cover all this on cross. But now, after attempting to offer Ms. Stanley as a witness, now she says she doesn't represent her. I don't, what is it? And I'm, not to be, I'll stop being glib and sarcastic. I'm unclear of what's happening here.
All right.
Who represents who? And if she doesn't represent them, she should not be allowed to give direct examination of any of them.
I don't know when the last time it's been involved in a legal proceeding before a court was, but so, in a legal proceeding, you can call witnesses on any number of subjects. They do not have to be your client. I think that is a pretty clear thing. I have named witnesses, several of whom are not my clients. Mustafa Chudnoff, not my client. He is a technical witness. Mr. Henry Sanchez, not my client. Mr. Ed Martinez, he is a member of the commission that I do represent, the ESACA Commission, but he individually, not my client. So I just want to clarify that I think that these objections are unfounded. And what my understanding was of what we were doing is because she had submitted ahead of the hearing, and I do think it's important to address, a request to provide us a statement. This essentially is her statement, which normally would be heard during the public comment period. But because I had listed her as a witness, we're allowing her, or my understanding was that this is what I was trying to do, is stipulate to just let her provide her statement now so that we don't have to have redundant testimony entered into the record.
All right. Thank you, Ms. LaCruz Crawford. Let me just say my general approach, and I think Mr. Vigil, at least, and the board members have seen this in the past. My general approach is to elicit the statements, elicit the testimony, and not to get hung up on what I consider a hyper focus on ways in which we can get hung up on procedural status as we walk through this. I want her to make her statement. I want her to be open to questioning, and whether she is being presented by Ms. Crawford or appearing pro se, which is what I have in the certificate of service. I want to get hung up on that sort of thing. So, Ms. Stanland, if you would, I see the Rhino matter on the screen, and to honor the point being made by Mr. V. Hill here, yes, you can point this board to a law case, but please refrain from addressing it as though you are a legal expert. As I understand it, you're not.
It's correct. I am not. And I would love to hear Mr. V. Hill's take on this case because it directly pertains to NMED and environmental justice, and perhaps he can speak on it because I do believe it is relevant. The residents, my understanding of the case is that NMED is to consider the cumulative environmental and social impacts in their review process. The residents of Mora County have suffered significant trauma due to the Hermit's Peak Cap Canyon fire.
Slow down.
This trauma includes not only loss of property and natural landscape, but mental and emotional hardship. The loss of property and loss of livelihood in these traditional communities has created lasting detrimental cultural and mental health effects. The Rancho Escondido Quarry has worsened these impacts for residents in the villages of Cleveland and Cordillera. Due to the industrialization of the quarry, the continued loss of natural landscape and environmental integrity has caused further mental and emotional trauma to the residents. The noise of the crusher and the equipment, the excessive dust, the increased truck traffic, the negative aesthetic effect, the environmental degradation of an open pit mine is causing continued mental and emotional harm. And in sharing also, the declaration of emergency that was signed by the governor. This is from the Department of Homeland Security and Emergency Management that was passed in 2022. And adding also the Source New Mexico article that the federal judge is ordering FEMA to pay the fire victims for emotional harm. Further, so this article was published on December 17th, saying that FEMA can no longer deny non-economic damages for the FEMA claimants. A federal judge ordered FEMA to pay fire victims for emotional harm because we have suffered emotional harm. In this context, we believe that significant public concern and the history of environmental degradation in our area is the basis for denial of this permit. In conclusion, I'm going to ask a couple of questions. That's okay. What do we need to do as citizens and neighbors to prevent something like this from happening? What can we do to ask NMED to be required to dialogue with, at the very least, the other bureaus in the department in the decision-making process? Surface water and groundwater are both relevant to this quarry, as it will be inherently interacting with groundwater over time. The groundwater is our drinking water. What is the role of the Environment Department, if not to protect our drinking water? What can we do to ask NMED to include all applicable federal, state, and county agencies in their permitting process? This quarry is in a FEMA floodplain, is in a FEMA disaster zone, is adjacent to community and private wellheads, and is above a shallow aquifer. This quarry has an acequia running through the area of operations, has no county permit or business license and has apparently no functioning water source. It also has no EPA permit and it has no restoration plan, leaving a 12-acre hole in the ground for future generations, and no one is responsible. If the Environment Department will not take responsibility for any of this, then who will? Thank you.
Thank you, Ms. Stanland. It is time to take a break. I'd like to take a break about every 90 minutes. When we return, the other parties and board members will be given an opportunity to ask questions of Ms. Stanland. So you will be back on the dais for that. Let's say it's 10:35. Let's come back at 10:50. Let's come back from the break, please. Ms. Stanland, if you would resume your. Just talking to Lisa. Let's come back from the break, please. You would. Ms. Stanland, if you would resume your place there at the dais. All right, I think I'm going to go to Mr. Behill or Mr. Hirsch first. And my understanding is the entries of appearance for Mr. Block and Mr. Sanchez specifically indicated that they did not intend to pursue cross-examination of witnesses. I will also ask at some point Mr. Maxwell if he has questions of you. But I'm going to start with, is it you, Mr. Behill? Okay.
Yes, it is. Thank you.
Go ahead.
Good morning, Ms. Stanton. Nice to see you again. What is your occupation?
I am a location manager for film and television. Location manager for film and television.
Okay, thank you. Thank you. And what is your educational background?
I have a bachelor's degree.
Okay, thank you. Thank you. Earlier, you indicated that the Environment Department appeared to you not to be listening. Is that correct? Not to be listening to the people of Mota County. Is that correct?
On the surface, NMED is listening. At the end of the day, they're not. That's my opinion.
And have you ever spoken to anyone in the Groundwater Quality Bureau?
I tried.
So you tried. Were you successful in that try? Did you actually speak to anyone?
You know, to be honest, I can't remember. I tried calling groundwater. I tried calling surface water. Oftentimes, no one would call back. So I don't know for sure.
You don't know for sure. Oftentimes, they would not call you back. So it would seem that it indicates that they did try to call you back then there were some times that they called you back.
Yeah.
Okay, they did. And at that time, did you speak to them?
Yes.
I see. So you did speak to them. Okay.
I don't know for sure if it was someone from groundwater, excuse me.
I see. Okay.
I don't remember.
Have you ever spoken to an NMED attorney personally?
Besides you guys, no.
You have never spoken to an NMED attorney on the telephone before?
You guys,
Yes, yes.
besides you two, no.
Aside from us, yes. No, it's fine. But you have spoken to representatives from NMED, and during those phone calls, did you raise concerns about this permit?
Are you talking about the phone call that we had?
Any phone call?
Yes.
Okay, thank you very much. Let's see here. Do you speak for everyone in Mota County?
No.
Is there anyone in Mota County that disagrees with you?
Certainly there is.
Okay, I have no further questions. Thank you.
All right, thank you, Mr. Behill. Ms. LaCruz Crawford.
Sorry, I was surprised how quickly that went. All right, so thank you for turning it over. Stanley, can you tell me where is it that you reside?
I live in an area called Encinal, which is about 3 miles north of the quarry.
How do you spell it?
Encinal.
And can you tell me how often you pass by the site?
Probably it depends, but I'd say 2 to 3 times a week.
Okay, and is the site visible from the road?
Yes.
And can you tell me, in your direct or in your testimony, you spoke quite a bit first about some of the history of the area. Is that correct?
Yes.
And can you tell me how is it that you know the history of the area?
Because I'm interested in history.
Okay, so would you say you've read about the history of the area? Is that your understanding?
Yes.
And how long have you resided near or adjacent to the Cleveland site?
I bought my house in 1995, so I've been there for 20 years in the same house.
Okay, and can you tell me, have you ever attended any events at the roller mill?
Yes.
Okay, have you attended events at the Hummingbird? I believe it was the Hummingbird Lodge.
Hummingbird Ranch. Yes.
Okay, have you attended events? There's a whole list of things that you referred to, but can you tell me, have you ever been to the Mora County, or not Mora County, the Cleveland post office?
Yes.
Okay.
That's where I get my mail.
Okay, and how often do you check mail?
Once a week.
Okay, and am I correct that you testified that post office is, in your experience, quite close to where the facility operates?
Yeah, it's about a third of a mile.
Okay, and in terms of your testimony, you also mentioned Pendleton Propane. Is that correct?
Yes.
Can you tell me how often you visit Pendleton Propane?
I'd say 2 to 3 times a week.
Okay, and do you purchase propane there?
I do.
Is there any other reason that you go there?
Yes.
Can you tell me why?
My partner works there.
Okay, and so when you've been at Pendleton Propane, have you ever seen any dust or visible particulate in the air at that location?
On the way to the location from the highway, yes.
Okay, and when did you see that?
That was at the end of November.
At the end of November of 2024?
Yeah.
All right, and have you ever seen other dust or particulate outside of this particular instance that you're referring to in November?
Yes.
Okay, and can you tell me when that occurred?
I couldn't say the exact date, but you can see it from the road. When they're loading the trucks, you can see the dust plumes.
Okay, so
I mean, anyone can see it from the highway.
okay, so you see dust that's coming off of the vehicles, is that correct?
Mm-hmm.
Do you know if the crusher is currently on site?
Yes.
Have you seen dust coming from the crusher?
I don't know.
Okay, but you have seen dust coming off of the trucks.
Yes.
And are those trucks taking material to the crusher, or are they doing something else on the site, or how?
Objection is that this seems to be direct testimony. I don't see how this touches on Ms. Stanton's statements. I just want to put my objection on the record. Seems like she's being directly examined and not cross-examined.
All right, thank you. 2 things. Mr. Behill, I'll give you a continuing objection as to that point. Ms. LaCruz Crawford, if you would please stay within the scope of her direct rather than expanding her direct. And finally, what I was hearing was perhaps a lack of foundation as to your final question. How would she know whether those trucks were hauling bits and pieces before or after they were crushed? That's all.
Because you can see it from the road. You can see the excavator loading the trucks
Okay.
and the trucks leaving.
Okay, I was only asking Ms. LaCruz Crawford to lay the foundation before the question. That's all.
Thank you. So I think that the witness has answered the question. At any rate, okay, I'm going to kind of bring things back in. So one of the things that I heard you talking about quite a bit also is a lack of permits at the facility. How is it that you have come to gather information about what permits have or haven't been issued at this facility?
Primarily through IPRA.
Okay, so you've submitted IPRA requests?
Yes.
Okay, and then what do you do when you get back the documents that you've requested?
Put them in a folder on my computer.
Okay, and do you review those documents?
Yes.
Okay, and is that the basis for your testimony regarding the permits?
Yes.
All right. And you also talked about, if I'm correct, and Clara, please let me know if I'm wrong, but you did provide testimony about the impact that the maintenance yard, which we in our jointly filed appeal petition had referred to as the annex for the site. Is that correct?
Yes.
Okay, and the can you clarify whether you personally have seen any impacts from that annex that have on you or any other residents that you've directly witnessed yourself?
Yes.
Okay, and can you explain what those were?
I mean, you can see the trucks. The trucks are parked right there from the Davidson's house.
And who do those trucks belong to?
Alivest Trucking.
Okay, and have you said that a second ago that you had seen trucks at the actual mine site? Is that correct?
Yes.
And do you know who those trucks belong to?
Alivest Trucking.
And how do you know they belong to them?
Because their sign is on the door.
Of the truck?
Mm-hmm.
Okay. All right. And so is it your belief that the consideration of the maintenance yard, I'm sorry, let me rephrase the question. Is it your testimony that the maintenance yard should be considered as part of the main area of operations for this site?
Yes.
Okay. And let me just look back here. I might have a couple more. Let me just look and make sure I don't have any more, but I think I'm pretty good. I was writing notes. Oh, just coming back to your testimony about the sites, the historical sites. Am I correct that you are concerned about the welfare of the public as a result of the activities that are occurring with the crusher specifically?
Yes.
Okay. How is that? I just want to separate out because you talked a lot about mining operations and a lot of things that would fall into the category of mining and things that were happening at the mine. But I think what I want clarification on is how this, in your opinion, impacts air quality or where you're seeing the air quality impacts.
I mean, the dust cloud that I saw was right over the quarry. There was like a massive dust cloud just blowing off. It wasn't necessarily a direct result of crushing or screening. It was because the land is barren. So, and there's no vegetation. So it just, when the wind blows, the dust just blows off. And it blows directly into people's homes. I mean, it's so close to everyone's house.
Okay, and can you tell me whether the I had a question on the tip of my tongue and I've lost it, but the you had also stated that there was a prior application to the Air Quality Bureau by Rancho Escondido for a general construction permit for the site. Is that correct?
Yes.
And how do you know that?
Because I saw the notice, the 8.5 by 11 sheet of paper at the gate when I was driving by, and then the UIPRA.
Okay, so you were able to see the 8.5 by 11 sheet of paper when you were driving by?
Yeah, because I was looking.
Okay, because you were looking for it. And why were you looking for it?
Because I wanted to know why there was a massive hole in the ground there.
Okay, so are you saying that at the time that the notice was posted that mining operations had already begun?
Yes.
Okay, and how were you involved? Did you protest that that permit application by Rancho Escondido in any way?
Yes.
Okay, so you were involved in the protest process.
Yes, through letters of objection to air quality.
Okay, and was that application granted?
No.
Okay, do you know why it was denied?
Yes.
Can you explain?
Because the setback was not met. The GCP2 requires a 1,200 yard setback, or 1,200 feet. Excuse me if I got that wrong. But anyway, there is a setback for it, and it wasn't met, and air quality denied it.
Okay, so are you saying that for that particular permit, your understanding is that there's a larger setback than the 67 meters that has been argued in this proceeding is the setback?
Right.
Okay, and so when that permit was denied, tell me, what is the relationship between Rancho Escondido and the current site and the current work that's being performed at the site?
My understanding is that Rancho Escondido is a company of the landowners.
And who is the landowner?
Raymond Olivas and Willie Olivas.
Okay, and can you tell me, so in your view, was that original application an application by the landowner for a more overarching permit to address conditions at the site?
Objection,
Or
this is
I'm
calling
sorry.
for hearsay.
Okay, I will retract that question. So when you were done with protesting that application and the application was denied, were you surprised when you saw a new application go in for the same property by PG Enterprises?
Yes.
And why were you surprised?
Well, I was surprised that it was PG Enterprises from Albuquerque, but I wasn't surprised that it was an NSR because basically air quality already told me that that was the loophole. I mean, when we first started protesting the GCP2, Rhonda Romero told me that if they don't get the GCP2, they can get an NSR,
Okay,
and that would eliminate the setback.
so do you see the use of the, and am I correct that that NSR permit application was, permit relocation application, sorry, was filed just 2 weeks after the denial?
That's correct.
Okay, but the landowner is still the same to your knowledge?
Yes.
Okay, so we still have do you know whether the landowner is still performing operations on the property?
Yes.
And how do you know that?
Because you can see it from the highway.
Okay, and what is the relationship between Olivas Trucking and the landowner?
It's their company.
Okay. And so you had testified previously that you have seen Levis trucks both at the main site and at the annex. Is that correct?
Yes.
All right. No further questions. Thank you.
If I could just add, we thought that they would do their own NSR. So when you asked if I was surprised, I wasn't surprised that they had gone for an NSR. I was surprised that they rented an NSR from Albuquerque.
All right, thank you, Ms. Stanland. Mr. Maxwell, do you have questions of Ms. Stanland? Thank you. Dr. Sinclair, do you have questions of Ms. Stanland? Thank you. Dr. Sinclair said she does not. Now we go to the board. Member Ely, do you have questions?
No questions.
Vice Chair Trujillo?
Yes, I just have a few questions. I just trying to get a better picture of the situation that you've been facing for a while. And so these are just clarification questions. I'm curious how long you've been dealing with this particular matter.
Since April of 2024.
And have you sought any other help with addressing the issue, like through your local county, any ordinances or county commissioners?
Yes.
Okay. Just look back at my questions here real quick. Oh, any of the public notices in the newspapers?
Yes, they were in the optic.
That's all I have. Thank you.
Okay, thank you. Member Hunter?
Yes, I just have one question. Ms. Stanlin, thanks for your testimony and providing input today. During your comments, you referred several times to a permit for the quarry. And I'm curious, is there another permit vehicle that's been issued for the mining operation, or are you referring to the permit, the NSR permit that we're considering on the appeal today?
To the NSR relocation.
Okay, so you're not aware of any separate permit for the mining operations?
Well, I'm aware of a lot of permits for the mining operation. They've been through like 4 of them.
Oh, okay. So are those permits in the record for this hearing? Or
No.
I'm just trying to differentiate in my mind what's in the permit we're dealing with today and what might be in the other permits. So
Member Hunker, I'm reasonably familiar with this record, and I do not believe the mining operation permits are in it, primarily because this board doesn't have authority over it.
okay. That clarifies it for me. Thank you.
Thank you.
Okay, Member Garcia?
Just one clarifying question. You mentioned that you have been in contact with Mora County. And did you find that this facility was in violation of any county codes or
Yes.
ordinances?
Yes, it is.
More than one?
Well, it's in violation of the zoning ordinance.
Okay, was Mora County going to take an action?
We don't know.
And do you know when you will know?
I don't know.
Okay, thank you. That's all.
All right, on the platform, Member Bitzer, do you have questions of Ms. Stanley?
Just one real minor. Council was asking about the academic credentials, and you seem to be pretty conversant in all this. I was impressed. I was just wondering what your degree. You said you had an undergraduate degree. What's the degree in?
It's actually a Bachelor of Fine Arts.
Well, anyway, well done though for someone who's not a lawyer. So I'm gonna.
Thank you.
Thank you, Member Bitzer. All right, is any reason not to excuse Ms. Stanland? No? Thank you very much, Ms. Stanland.
Thank you.
All right. I'm gonna call Ed Martinez. Oh, actually, before Miss Stanley goes, I do not believe, was she sworn in?
Yes, she was sworn in.
She was, okay. All right, I just wanted to confirm because I do not remember her being.
You can check the tape.
Okay, thank you. All right, that's all.
And now we'll swear in Mr. Martinez, yes? Do you swear or affirm that the testimony you're about to give will be the truth?
Yes, I do.
Thank you. Go ahead.
All right, can you state your name for the record?
Yes, my name is officially Horacio E. Martinez. Normally, I'm called Ed.
All right, and can you tell me whether you serve as a commissioner on the Acequia de Alto y Los Martinez?
Yes, I am the treasurer of the Acequia de Alto y Los Martinez.
Okay, and how long have you served in that role?
I have been working on that role since 2014.
Okay, and can you tell me whether any portion of the Acequia passes through the plant that's managed by PGE under this permit?
Yes, the Acequia has two branches coming out of the mother ditch. And the mother ditch, there is one ditch that comes off the main river. It's divided into two branches, which is the Martinez branch and the Alto branch. Both of them pass through the area of the Olivas. The Martinez branch goes right through against the quarry of the Olivas.
Okay, and I'm going to need, I believe I'd like to screen share here, so I may need a little assistance with this. I'll do my best.
Can you spell?
Madre, it's Madrea.
Just RE, yeah. Okay. My screen share from here. I've got the document up.
So she needs to be allowed to enter the meeting.
I think I'm in the meeting.
Oh, so
It does say join the meeting now. Maybe it logged me out. That is. Well, now I'm out for sure, but it said Andrea LaCruz Crawford, and then it was my email, Andrea@streetperform.com.
She's having to re-enter her information.
Hold on. I guess there it comes. Hold on. Okay, here we go. I should be coming online now. This meeting. All right. Good. Okay. Believe this one. All right. So all right, looks good on their screen. So I'm good. All right. So okay. Mr. Martinez, can you tell me and I'll just for the record, I'll just say this is Acequia's Exhibit 4. Can you tell me what this document is?
Yes, that is a picture of the Acequia right up against the quarry that I took during one of the inspections of the area.
Hey, and when was this photograph taken?
Gee, I don't recall the date, but it was after the the area had been cleared from trees, and Mr. Olivas and I had been communicating about the trees in the acequia, and I went over there to review the acequia and see that it is free of the trees and the debris in it. And it was a photograph that I took, and I noticed that the pad of the quarry or had been moved up against the acequia at that point.
And do you recall whether this was in the summer of last year?
Yes, it was summer of 1924.
1920?
Excuse me, 2024.
You sure you're not that old? Let's
No,
see.
my father was.
And I'm going to go ahead to second photo here. And can you tell me, is the area that's shown here and where was the screener in place at the time that you went to visit the property?
Yes, the screener was in to the left of the photograph inside the quarry, inside the pit. This is looking from west to east, water running downstream. The acequia is in the green area. The Olivas equipment is on the left, and a pad had been placed on the side. They had cleared the trees on the right side. There was a lot of debris on it, so I was really interested in making sure that the debris didn't get into the acequia.
Okay. And am I correct? You see burned trees in the background of the photo?
I don't know that I can see burnt trees. They had been removed already, and the man responsible for removing the trees had already taken them off the area.
Okay. And so would you say that this area was impacted by the Hermit's Peak Canyon fires?
This entire area was burnt, and the whole area where the quarry is at was also burnt. So there was, I'm not sure how many acres, but this whole area was part of the Hermit's Peak Canyon fire.
And can you explain what the condition of the acequia was at the time that you conducted this visit?
When we walked through the acequia, it had water, and there were areas where there were sticks in the acequia. They had been blocking the flow of water, collected sand, ash throughout the area. And at this time here, we had had a flood, and I don't recall directly whether the area had been washed out or what was collecting there, but it was a constant attempt to keep the acequia clean. And I remember talking to Salomon, Mr. Olivas, constantly about making sure that the area was cleaned. And at one time, we worked with one of his employees. He went into the acequia with a track hoe and cleaned the area that had been backed up. So we're constantly, over the course of the summer, making sure that the area was clean.
And can you tell me when you went to the site on this occasion, was this before or after the permit was issued by the Air Quality Bureau, the underlying permit in this application?
This was right about the time when they were changing to the permit for PG Enterprise.
I'm sorry, can you clarify what you mean by that when you say changing to the permit?
They were operating originally or we thought that they were operating on a permit. The original permit, which I don't recall how they're named, but it was the one that Olivas had asked the Air Quality Bureau to use, and then they went to the PG Enterprise permit. That was right about that time. There was no crusher at this point. The screener was inside the pit, and I'd have to go back and look at the dates when I took the photographs. But it was right around that time where they were changing or applying for the PG Enterprise relocation permit.
And I am going to ask, so I do notice that there is what appears to be a handwritten date there on the photograph. Is that something that you wrote on this photo?
Yes, probably so.
Okay, and do you recall writing a date on this photo?
Yes, I do.
Okay, so if I tell you that the date, I don't know if you can read it up there, but it says 8/27/24. Would that seem
April,
accurate?
yes. Yeah, that seems right.
Okay. And can you tell me whether the fires affected the acequia?
Yes, they did. One of the biggest things is that when the fires came, they basically destroyed a lot of the material that would hold the water from flowing. So we had this flash floods that were coming into the acequia. The acequia would get full of trees, debris, rocks, and they would actually cover the acequia in its entirety so water would not flow through it. So we had to constantly be going in with equipment and cleaning the acequia. And then we would walk the acequia after we did a lot of the major work with the equipment. We'd walk the acequia, remove the branches that were loose, and they would be piles of sand and debris on it. It would go open the water in the river, and the river would wash the debris downfields in order for us to allow the water to flow into our pastures for irrigation.
Okay, and can you tell me, do you still um so when you're referring back to we would have to go and clean the acequia, is that still the situation today, or is this have you cleaned it all up and that maintenance is now done?
No, we do this on a constant basis. This last year, in the year 2024, we went in on this particular branch of the acequia 13 times to clean, to remove, to walk with FEMA and have them review the work that needed to be done so they could recompense us for the fire effect on the acequias. The Alto branch, that one we probably went through maybe 3 or 4 times because it is not as highly affected. It was not burnt as bad as this particular one, but we have to constantly be addressing the issues of the debris in the acequia.
Okay, and so if you already covered this, please let me know. What happens when it rains?
When it rains, what we do is we anticipate that there's going to be a flood event. The mayordomo will go and close the water off the main river as to not amplify the water in the acequia. There is a scar, a burn scar in the area that's really, really bad. And we basically try to avoid overloading the acequia with water, so we close the river off. If we don't close the river off, then you have twice as much water, a lot more water in the acequias, and they flood and they plug and they create a lot bigger problems. If we don't catch the water in the river, or we don't catch the close the gate in the river, then we have a big problem. So we try to do that. But we can't cross the river because of the flood can actually affect our lives. So even when we go with equipment in there, this last year we had to go in there with a big tractor to try to close the gate off. So there's a constant anticipation of the rains. In the year 2023, we had 3 major flood events. Last year we only had 1 big flood event. And we're anticipating, not knowing exactly what the environment will do, what's going to happen. So we are constantly watching for the flood alerts, the cells in the sky that might drop rain right on the burn scar, because it really does affect the acequias. Now the there are 2 mayordomos that are constantly watching what goes on, and myself and other the commissioners constantly looking out for rains to anticipate this. So we're always aware of what's going on because of the fire and because the floods basically destroy the acequias.
Okay, and does the acequia hold an easement through the site?
Yes, we've always gone through the acequia easement for the cleaning, and we've done this either by hand, by equipment, and it's been common knowledge that we don't ask landowners permission anymore. Basically, they know that when the mayordomos traco or tractors are coming through, they know that we are addressing the issues of cleaning the acequia because if there's an issue. If there's a tree that's fallen over because the wind blew it, that we can't pick it up by hand, then somebody will bring a piece of equipment, we'll move it out. So we are constantly doing that.
Okay, and so would you say that it's safe to say that anytime it rains, the acequia needs to have access to the site?
Yes.
Okay, And also, if I understand your testimony correctly, the Acequia does not need permission to access its granted easement. Is that correct?
We have never asked for permission. Basically, it is understood in our bylaws that access is granted automatically.
Okay, and can you tell me, did the Acequia place a culvert? I'm just gonna keep going through these photos so you can just see the photos that are up here. Let's see if I have a picture of the culvert. These ones. Well, before I go on to that, let me just ask you, I'm looking at page 4 of 6 of Exhibit 4, which I'd like to just go ahead and move to enter into the record. And in fact, I think we've reached a stipulation with regard to the exhibits of the Acequia and the department. We're just going to stipulate to entry of all those exhibits into the record so that we don't have to worry about trying to lay additional foundation we wouldn't normally want to.
Thank you very much, both of you, for working that out. Mr.
Yeah,
Beal.
no objection for the.
Thank you.
Okay, so on this, now I'm looking at page 4 and looking at that photo. Can you tell me directionally where the crusher would be in relation? I know we can't see it in this photo, but where would the crusher be in relation to this image?
On the right side, right where the yellow piece of equipment is at.
So was that equipment there at the time that you walked through the site?
Oh, yes, it was.
Yeah, I'm trying to see if we have a picture. The first, okay, we go back. This one doesn't show it. Okay, well, I'm not able to see it. Can you tell me visually, in your estimation, as just a layperson, how many feet was the crusher from the Acequia at the time that you visited the site?
At this moment, there was no crusher.
At that moment, there was
no crusher.
but there is a crusher now.
Yes.
Okay, so all right. So thank you for clarifying that because I think I was confused about your testimony. So what you were saying when we're looking at page 4 here is that the approximate location of the crusher today would be where the yellow piece of equipment is in the photograph.
Correct.
Okay. Has the Acequia in this area been placed into a culvert?
Repeat, please.
I'm sorry. Okay, so there's in some of these photos,
The one before.
there's a actually the very first photo here. Let me get back up here.
Yeah.
There's a roadway and there's a culvert. When was that culvert installed?
Yes, when the Olivas had cleared the land to the right, and I believe they were clearing the land to the left. Actually, they installed a culvert to get the trucks that go pick up the logs, and they had to cross the ditch. Typically, there's a low water crossing that we would put in so that trucks basically go, and you don't have to install a culvert. But the Olivas at this point here installed a culvert to get their trucks across to the left side of the photograph.
Okay, and so prior to the culvert being installed, the trucks would just pass through the lower
No.
water crossing?
No, there was not. Typically, people would have done that, just put a low water crossing if you want to get to the other side. But the Olivas put the culverts in order to get to the other side to remove the logs.
Okay, so is this a haul road that was created for the site?
That was a haul road that was created, yes.
Okay, and did Mr. Olivas request, and I should clarify, when you say the Olivases, who are you talking about?
Solomon and because Mr. Solomon is the one who I've interacted with.
Okay, so and you had said that you had spoken to Solomon about the Acequia issues. Is that correct?
Yes, as being a commissioner of the Acequia, and he had the bylaws. He knew what had to be done on those. So basically, we understood each other that he knew what had to happen on the Acequia.
Okay, and so did he obtain permission from the Acequia Commission to install that culvert?
No, he didn't. And we, at that moment when he first put it in, we did not want to be. I mean, we want to be humane about things that we go. And since he was part of the team, he did we didn't really push the issue, but he went and installed a culvert, and we thought, well, it's okay. He'll come back and tell us what he's doing, but it didn't happen. And then at that point, I think we made some reference to, hey, Mr. Olivas, I think you need to ask the mayordomo for permission to install this culvert. Just on a passing note, Mr. Olivas then proceeded to install the second culvert, which he needed for the width of the trucks. Because at that time, Mr. Mustafa and I had done a walkthrough of the area, reviewing the area of what was being done to the acequia. And we realized that at that point, the second culvert had been installed, and there were issues now with this installation, and realized that we had not given Mr. Solomon or Mr. Olivas permission to install those, and he did not ask. Typically, I contacted the mayordomo. He had not been informed that the culverts had been installed. So we knew there was an issue at that time. So recently I told the mayordomo, I think you need to tell Mr. Olivas that he needs to ask your permission. So the mayordomo, Mr. Eloy Perea, sent a letter to Mr. Olivas and did not, and we have not heard back from him asking permission to install the culvert. So
Okay, and can you tell me, does the acequia have a set of bylaws?
yes, it does.
And does it have a provision in those bylaws that addresses whether or not permission is needed before making improvements?
Yes, it does.
Or changes to the ditch?
Yes, it does.
Okay, and
Hold on, Ms. LaCruz Crawford. Yes, hold on. Please do not have conversations in this room. Take your conversations out. Go ahead, Ms. LaCruz Crawford.
okay, and right, my apologies for not, I didn't notice, it was just proceeding. What is the condition of you now? Is this the culvert that we're seeing in these photographs in Exhibit 4? Is that's a separate culvert from the one that you're saying was installed after that?
There are two culverts at that point. I think there are two 20-foot length culverts in there, and they're joined in the middle.
Okay, but they're at different locations, or are they?
Same location.
Okay, and what is the current condition of the culvert?
Well, the last time that I walked the acequia, the FEMA people and the lawyers from Roybal Mac walked with us the acequia. I looked, there was no water because we had stopped the water because there was a flood event. We stopped the water, and the ditch was where the acequia was dry. So I looked inside the culvert, and the collapse between the two sections, the joint had been collapsed, and it was still collapsed. I sent a text to Mr. Olivas, and I told him there's a collapsed joint still. He says, I am aware of it. I don't know. I haven't gone back to review whether the culverts have been repaired.
Okay, so with that collapsed joint, can you currently get your normal flow of acequia water through the culvert?
Well, the issue is not the normal flow, but if you were to plug the acequia in that joint because of the collection of material in it, it would back up the culverts and basically overflow out of the acequia. And I mentioned this to Mr. Olivas. There's a possibility because we are in a flood zone that the water will overflow and go directly into the quarry. And he says he was aware of it, but I do not know the condition of the
Okay, so
culverts now.
does the condition of the culvert impact your acequia's ability to get water?
Yes, it does. If it were to be plugged.
Okay, and so at this point, has it impacted the ability to get water?
No, it hasn't.
Okay, all right, and can you tell me, has the site as created altered the flow of drainage?
We don't know that. And what we did is I asked the New Mexico Acequia Association to help us with this issue. And what they did is they funded two hydrology reports that are out in the public now to address the issue of what happens with the acequia if you dig a big hole right beside it. So I do not know. The hydrology reports talk about hypothetical situations, also about the theory of how that aquifer is there, how the acequias are affected. I don't have the technical knowledge to be able to answer that question.
Okay, but you're aware that some expert reports have been created that address the drainage?
That's correct.
Okay. So in terms of this haul road that was created, that was done without the permission of the acequia by installing a culvert through the acequia's easement. Is that correct?
That's correct.
Are you concerned, given the location of the crusher, and would you, how far, I don't know if you answered my question previously about how far just visually you would estimate the crusher is from the acequia?
The crusher seems to be maybe, I'm not sure exactly how many, 25, 30 feet from the acequia. The wings that bring the crushed rocks out, there seems to be 3 wings. One of them is probably right on the edge. If I were to look at this picture, it's probably between the green, right at the edge of the green, because the land has been re-leveled and resurfaced in order to allow to the tractors to walk in there to pick up the material. There are 3 wings that actually bring the material out, and you can see those from the aerial photos. And the main engine is probably between the crusher and the acequia. That area is probably 20 feet, 30 feet probably. So it's very, very close. We have not been there since we walked with the FEMA people the last time, and the crusher was there, but it was not installed. It is now installed, so now you can see aerially, but there's no way that we can measure that. We walk the acequia, we walk right alongside it wherever we can, but we're not there to inspect distances. We're there to see the condition of the acequia.
Okay, and so just looking at page 6 of Exhibit 4, so can you tell me where the crusher, what, do you know what these vehicles are, just so I can verify what these are?
The blue is the screener.
That's a screener, okay?
Yes, and I think at the upper right-hand side, there's a transportainer that I believe has the equipment. That's an orange-like building.
Okay,
And then there are there's probably excavators there, probably that yellow, a little bit to the left.
okay, and those vehicles, do you know who operates those vehicles?
No, I don't.
Okay, do the vehicles have any labeling on them that you're aware of?
The screener has a label on it, but as far as anything else, I think they're Caterpillars,
Okay.
Cat equipment, but I don't know who owns it. There are no label marks of ownership.
Okay, and can you tell me what do you know about who is operating the site?
I don't know who's operating the site. We have seen when we walked the acequia once, there was a gentleman there who actually cleaned the acequia for us. And I believe he worked for Mr. Olivas. He said he was one of his workers, but we have not encountered anybody. We're not on site. Everything that we see from far away. I don't see, we see trucks moving out there. We see Mr. Oliva's yellow trucks moving, taking out material, but we don't interact with any of the personnel whatsoever.
Okay, and so you see vehicles, you see equipment. Have you ever run into anybody from PG Enterprises who's at the site?
No, I don't. Yeah, we haven't seen anybody there that seems to label on a truck that says PG Enterprise. Basically, we just see the Olivas trucks there.
Okay, and can you tell me, given the current location of, also on here, so you're saying that the current location of the crusher, which was not in this photo, is that correct?
That's correct.
And it was approximately where there are these 2 trucks below kind of this box.
That's correct.
Okay. And are you concerned about exposure of members of the acequia to particulate matter from the crusher?
Well, my thought has always been that if the crusher is near the acequia and we're running water, any particulates within that perimeter that has been defined as a safety zone, and if it's not that close to the acequia, then we are getting particulates in the water and they're flowing downstream. In the summer, we irrigate our gardens and basically use the water for chickens and that kind of stuff. In the winter, we use the water for our cattle because most of the cattle come down from the mountains, and the local ranchers have their cattle down in the valley. So my concern is that if dust is being generated or particulates of crushing and they fall in on the acequia will actually carry the water downstream into La Corriera, the valley where we live, or if they settle in the soil will then get the particulates, and I'm concerned that there might be an effect. I don't know that, but I believe that there's a possibility.
Okay. And are you concerned about the pit that's being created at the facility, or that's been created?
I brought that point up to the county when Mrs. Stalin and I both have presented the county on probably 3 or 4 occasions with concern that this hole in the ground will, first of all, it has not been county permitted. And I have spoken right beside her to the county governments, and they have been inactive in doing anything for us. But the pit itself, if I think about it from just a layman's point of view, and the floodwaters off the acequia basically going to the pit, it becomes a dam. And I believe that that dam then picks up all the particulates that are in the process of crushing and basically going to the soil. Then the aquifer is in a very, very shallow area. Then that area will get into the drinking water of the valley. So I'm really concerned with that. And we've expressed that concern to the Mora County commissioners, to the planning and zoning. And we've done that on multiple times. And
Okay. Okay. Did you have something more you
No.
wanted to say? All right. What types of, I'm coming back to the maintenance of the acequia, okay, because for me, this is an important topic of discussion. What types of equipment do you use? I think you said that you do use heavy equipment. What's the largest piece of equipment that you typically use to work on the acequia easement?
we use a Caterpillar Traco 308.
Okay.
That is one of the mayordomos has that, which is Frank Tremblay. He uses that to basically open up the ditch. Tremblay, in Tramble way. The other mayordomo has a Ford 50 horsepower New Holland, and I have a Kubota tractor that I use with a backhoe to open areas where we can get in with big equipment.
Okay. Does the acequia currently have any projects that are underway?
Yes, right now the NRCS is providing a series of culverts that are just above the Olivas areas in order to try to mitigate the destruction of the acequia every time it rains. When it rains, the burn scar area floods the entire area where the acequias are at and covers them up completely. So that requires that we go back in with equipment and open up the acequias again. And normally it's close to, there's 1,000 feet of culverts that will be installed by NRCS. And the contract is out for a company in Albuquerque. Now, what will happen is that the flood waters will no longer run into the acequia. They basically will run over the acequias and as if they did after they leveled the acequias. And the waters will end up in the Olivas land as it has always been. Now, in the past, the forest was there. So the forest would slow the flow of the waters down. They'd basically collect whatever debris might have come. But there was really never any big floods in the past. But now we're seeing the floods in that area. So that mitigation work that NRCS is doing now, and the contract is out, will start this spring or probably late winter, and basically change the contour more or less of the mouth of the flood zone in that area, because we are in a flood zone. Both Acequias, the Alto branch, and the Martinez branch, both all in a flood zone. The Corrieta area where we live is part of the flood zone. So I'm really concerned that, the mitigation efforts that we have done are going to change a little bit. I've asked the.
Okay, and hold on, I do want to actually back up. I don't want to go off on a complete tangent
Okay,
about
thank
this.
you. Sorry.
But what I did want to ask you is, will you need to pass through this site in order to do the work that will be performed in terms of this stormwater drainage plan and remediation for the acequia?
No, we have gotten permission from two of the other landowners above the Olivas land that they have given us permission to do the work that needs to be done.
Okay, so you won't, for that particular project, you won't need to pass through the site.
No.
Can you tell me, is there any time of year that the acequia does not need regular access through the site?
It's in the winter, basically, because we can't do anything in the winter. Right now, the acequia is iced up. Basically, it freezes. If anything is there, we cannot clean it. We wouldn't do any maintenance in the winter.
Okay, and outside of the winter, at what time of the year do you transition? Is the acequia no longer used? What would you define as the months for winter?
The water always flows because we have to maintain irrigation or drinking water for the animals. So the water always flows, irregardless.
Okay, so the water always flows, but you don't need to go in and regularly maintain it?
That's correct.
Okay, and what if, what about storm events during the winter? The reason I'm asking this, I know sometimes.
Objection relevance. This is a permit relocation. I understand this is all very interesting. It's fascinating, in fact. I don't know how much of this is relevant to whether or not the relocation was done in accordance with the law.
Ms. LaCruz Crawford, is this line of questioning relevant to proposed new permit condition number 9?
Yes, that's correct.
Please go ahead.
Okay. And I will cut you off a little bit more so that we can get through your testimony. Okay.
Yes.
So, so if I understand your testimony correctly, you need to be able to get large vehicles into the site. You are there throughout the spring, all the way into the fall, and that at some point, you stop going into the property for the winter and just allow it to flow for the animals. What time do you stop going into the property?
November, December, probably.
November and December. Okay. All right. So are you aware that the department, I believe 1 or 2 days ago, issued a new permit condition?
Yes, I am.
And can you tell me what your understanding of that permit condition is?
I believe that the statement says that when we are to do our cleaning of the acequia, we are to inform the owners of the land, and they will shut any crushing operations down.
Okay.
So we can do that operation.
Okay. So how do you anticipate that permit condition will be implemented given the frequency that the acequia needs to go in to maintain the acequia across the site?
I don't know, because we cannot predict the flood events. Every flood event requires us to go in there.
Are you aware that the permit contains a requirement that the particulate emitting machine being the crusher, has to be at least 67 meters from the nearest fence line.
Yes, I am.
Okay. Do you think if that same permit requirement existed, but it said from the acequia, that would be protective of the members of the acequia?
Yes, I believe that would minimize the amount of particulates in the water.
Okay, and would that minimize exposure of the members of the acequia as they're going to clean and maintain the ditch?
Well, that makes, I'm confused about that because they would not operate when we are cleaning the acequia.
Okay, I do understand what you're saying there. Okay, so I suppose that my general question is if the crusher was moved to be at least 67 meters from the acequia, do you think that would be a beneficial permit condition to add?
Oh, yes.
Okay. So I'm going to move on to the next exhibit. So I'm going to pull up our exhibit number 5. That was a different. Okay, we'll just do 1 or 2 questions on this. It'll be quick. All right. Okay, so up on the screen now is the acequia exhibit number 5. Can you tell me what this is?
Sorry, Ms. Cruz Crawford, I apologize for interrupting you.
Oh,
This in the SOI says that this is Exhibit 6.
okay. Hold on. What did I just write? I might have written it down wrong here.
I just wanted to be clear what we were looking at, that's all.
Okay, no, you're correct. So this, are you sure that's 6? Let me look at my, hold on. I'll apologize. Try and get through it. Let me ask you a question or two about this while I figure this out.
Yes.
Okay, so the image here, is this marking the FEMA floodplain information?
No, it's not.
Okay, what is it showing?
Basically, this shows the entirety of the quarry and the acequia on the upper section of the picture.
Okay, and am I correct that the crusher is still not shown in this image?
That's correct.
Okay. All right. Let me see. Let me pull this down. Okay. Do you think that the fires have impacted the air quality in the community where you reside?
Oh, yes, it is.
And how do you think that it's impacted the air quality?
Whenever the wind blows, it seems like we have more dust in the air than we did before.
All right. And why do you think that is? Just your lay opinion, not as a technical expert, but what is your reason? Why do you think there's more dust in the air?
But there is, for a period there was a lot less vegetation. The vegetation is now coming up. There's this invasive weeds that have been showed up. But for a period of time after the fire, everything was just ash. And for the first year, when the wind would blow, it would just blow all this ash in the air.
Okay. Okay, I'm going to go ahead and pull up our exhibit 8. Second.
Pull up ours.
8. I hope it is properly labeled. All right.
Ms. Cruz Crawford, would you estimate the remainder of your?
I think that I do have a number of questions still for this witness.
Okay.
So, I could just get through exhibit 8 and we could take a break.
Okay, go ahead.
All right. So can you tell me what this exhibit is displaying?
Yes, it shows to the left of this picture would be look the Mora Inn, the Cassidy area, State Highway 518. They're in the foreground. It shows most of the Olivas land. And then it shows the burn scar to the upper end of the picture and Cleveland to the right.
Okay, and is this a photograph?
Yeah, this is a photograph.
How was this photograph taken?
I took it with my camera. I went to Mr. Dan Cassidy's place. I got on the hillside there and I took this photograph.
Okay, so this was taken from the hillside?
Yes.
All right. Mr. Cassidy has quite a view. All right, so I wanted to, there's a couple labels on this photograph, one being the Davidson House.
Yes.
Can you explain to me what that is?
The Davidson House is a house that exists right alongside the annex that Ms. Sandlin described as being alongside the annex of the Olivas.
And so are you saying that this is the annex that you had heard prior testimony about with regard to the maintenance yard? Is that correct?
That's correct.
All right. And so have you ever seen or been to this the area where the gravel quarry annex meets the property line with the Davidson house?
Yes, I have. You can see that from the highway.
Okay. And so is there a fence line between the annex and the Davidson house?
There is a fence line, yes.
Okay. And how far would you say the fence line is between the Olivas property and the property belonging to the Davidsons?
Well, the
Objection relevance.
Ms. Cruz Crawford, what is the relevance?
I'd say it's highly relevant to establish that there is no setback and that this area should be considered as part of the area of operation.
Setback for what?
There's a 67-meter setback requirement from the nearest fence. The area of operations, as we have argued in our notice of appeal, should include the gravel quarry annex. And so when you're assessing the site and the setbacks, we believe that you should have to look at the impacts to this residence that is located literally with zero setback from the annex.
You believe, or is that what the law says? We're not here to assess belief. We're here to see if we adhere to the law.
Hold on, Mr. Behill and Ms. LaCruz Crawford. Mr. Behill, if I remember from the department's documents, the Bureau is taking the position that the setback is from where the generator is sitting. Is that correct? All right. So I understand you have a disagreement as to how this board should interpret the setback requirement. But I'm going to let her finish her question and argue for the interpretation of the law. Obviously, they are pressing. Go ahead, Ms. LaCruz Crawford.
All right. So can you just tell me, is there, as far as you know, is there any setback whatsoever between those two properties?
none whatsoever, to my knowledge.
All right. All right. So I think that I can go ahead and we can break.
Okay.
I will want to come back to this witness though after the break.
I understand.
Thank you.
I have another thing, though, to do before we take a lunch break. In the notice of the hearing, I believe there was some mention that we would invite public comment between noon and 1. More recently, I had correspondence with the parties that we would take it after lunch, not during lunch, so that this board can, and the court reporter and all the rest of us can have a lunch break. But let me ask, before we break for lunch, is there anyone in the room who is here to offer public comment and cannot rejoin us after lunch. Ma'am, okay, and sir, okay, you can come back after lunch. An hour. Okay, so we will accept your comment and yours as well if you have the same answer. Let me know also if there is someone on the platform who must offer their public comment now and cannot rejoin us after lunch. Please reach out to Pam Jones, who is your virtual host here, and let her know. Otherwise, I will take as much public comment as there is to be given after lunch. So, Mr. Martinez, if you would step away there so that we can have this woman offer her comment. Please go up. Just a few things about public comment. I will ask you to state and spell your name. I will swear you, and I will ask you to keep it to 3 minutes. And I can only invite public comment from each person once. If you have more to say than can be said verbally in 3 minutes, I will ask you to put that comment in writing and send it to Pam Jones. This board will be able to consider it as though you spoke it. So if you would please state and spell your name.
My name is Lisa Jordan Stiles, Style.
Thank you. Do you swear or affirm to tell the truth?
I do.
I will start your 3 minutes.
Thank you, and thank you for this opportunity today. I am here today to oppose the permit of enterprises. Our community in Cleveland has been traumatized by the Hermit's Peak Canyon fire. It's still very real in our lives. We live with it every day. Our magnificent forested mountain landscapes were reduced to charred moonscapes. Our wildlife populations have diminished. I'm sorry. You need me to start over? Okay. So I am here this morning to oppose the permitting of PG Enterprises. Our community was and still is traumatized by the Hermit's Peak Calf Canyon fires. Our magnificent forested mountains were reduced to charred moonscapes. Our wildlife populations have diminished to almost nothing. We live with the aftermath of these fires daily. Thankfully, we still have clean air, fresh water, peace, and quiet. I respectfully ask that you do not take these precious resources from us also, which is exactly what is at risk if this permit is allowed to move forward. I thank you for your time.
Thank you, Ms. Stiles. Sir? If you would please state and spell your name.
Good afternoon. My name is Ambrosio Olivas, Ambrosio. Olivas, Olivas.
Mr. Olivas, do you swear or affirm to tell the truth?
Yes.
I'll start your 3 minutes.
I'm here today in support of my uncle Salomon and my father Willie Olivas and their request for the permit of the crusher. Having talked to my dad for the past couple of months about this, he's talked a lot about how he wants to do it right and make sure that we get all the right permits for it, so we do it in the proper way. There's a lot of arguments I heard today that I didn't think were necessarily true, or they're a bit overextended to side in their favor. But I think going forward, if you, after hearing what they have to say and all their arguments, I think you could side with us in getting us that permit to let us build our company and continue to help the state with the roads, with all the dirt and the material that's going to be used for that pit. And yeah, that's my statement.
Thank you, Mr. Olivas. Anyone else in the room who must offer their comment at this time and cannot rejoin us after lunch? Pam, was there anyone on the platform?
No, no one's indicated an interest in speaking at this point.
All right, let's return at 1:15 and we will continue the hearing. Thank you all. Welcome back. We are back after the lunch break in this permit appeal, EIB numbers 24-51 and 24-52. When we broke for lunch, we had interrupted Mr. Martinez's testimony in order to take some public comment, and we'll return to public comment now before we return to Mr. Martinez. This will not be the only opportunity for public comment. I'll invite it again later this afternoon. But if you would like to offer public comment and you're currently in the room, please raise your hand. Okay, I see 2 hands over here. All right, and then I will turn to the platform to invite public comment from the platform as well. If you already know that you want to offer public comment, please let Pam Jones know through the chat or via email, however it is you'd like to do that. So let's start with you, ma'am, in the purple vest. Just a couple of things. I'll ask you to state and spell your name for the transcript. I will come up here to the dais. I will ask you to swear or affirm to tell the truth, and I will start a timer for 3 minutes. If you have more to say than can be said in one comment for 3 minutes, please write it out and email it to Pam Jones. So, ma'am, state your name and spell it.
My name's Elizabeth Blackwell, Blacabeth, Blackwell.
Thank you very much. Do you swear or affirm to tell the truth?
Yes, I do.
Thank you. I'll start your 3 minutes.
I have already. I want to thank you all for providing us the opportunity to do comments. I have sent Pamela a email regarding my opposition to this brochure. But I wanted to just add that I live less than a mile from where the crusher is as a crow flies. And it's unbelievable the noise that we hear at my property, either weekdays or weekends. It is horrendous. My parents, have lived. I acquired the property where my parents lived, and they lived here since 1929. So, we would appreciate that this crush not be allowed. Continues. That's it.
Thank you very much, Ms. Blackwell. Sir? If you would state and spell your names, please.
My name is Henry Sanchez, HenrySanchez.
All right. And Mr. Sanchez, I saw that you were also noticed up as part of the SOI from petitioners. If I accept your public comment now, I have to limit it to 3 minutes. If you have more than 3 minutes, I would invite you to come back to us in a little bit.
Understood.
Okay. All right. Do you swear or affirm to tell the truth?
I do.
I will start your 3 minutes.
Okay. My concern basically is the impact on our water and our air. We have our community is served by a water association, and from the hydrology report that I read, it seems that it would impact our wells some sooner than others. It seems to me that I can protect myself from a plume of dust that I can see, but I cannot protect myself from particles that I cannot see. I don't live that far from the area of operations. Uh, I do not have the wherewithal to relocate and say, well, you know what, I'll just move and protect myself that way. So I have to bear whatever consequences I face coming up. On the end of the water, our water association serves approximately 385 people. We probably use about maybe 1 million gallons a month, something like that, maybe a little bit less. Maybe probably a little bit less now in the winter. People are not consuming as much water now than in the summer. We don't know why, but all we have on hand is a hydrology report that gives us concern for our drinking water. And air and water are two of the most precious things that we have. We cannot replace that. We can't go back and get a redo on that. That's it. Thank you.
Thank you, Mr. Sanchez. Anyone else in the room? Again, there will be other opportunities later this afternoon. Pam, did anyone reach out to you from the platform?
Yes.
Sophia Martinez.
Ms. Martinez, if you would unmute yourself.
Yes, thank you. And thank you to the Air Board and the folks that are participating today. My name is Sophia Martinez. I'm president of the Concerned Citizens of Wagon Mountain, Mora County, and co-chair of Los Jardines Institute in Albuquerque, New Mexico.
All right, hold on, Ms. Martinez, hold on. First, I believe your first name is spelled Sofia.
Yes.
Okay, and do you swear or affirm to tell the truth?
Yes.
And the court reporter is asking that you slow down so that he can capture your words for the transcript. We also have interpreters who are trying to capture words. So go ahead, I'll start your time.
All right. Once again, my name is Sophia Martinez. I'm co-coordinator of Los Jardines Institute here in Albuquerque. We do work around food and environmental and economic justice. I'm also president of the Concerned Citizens of Wagon Mountain, Mora County, and that organization also does work around environmental justice issues. And we support the community in really not wanting this particular industry in their community. We're very concerned about not only this particular issue, but also across the state with a lot of the gravel permitting that happens. Most of those are movable permits that can move across the state. And we're very concerned about really the lack of oversight from the New Mexico Environment Department. Recently, we have some folks that bought land right next to Wagon Mound, and that's one of the big oil companies. The Yates Company bought land just about a mile from Wagon Mound, and they began doing some exploratory drilling there, and basically did some dynamiting within half a mile of our the Santa Clara Springs, which is the main municipal water source. And you can't do dynamiting that close to a water source, right? So municipal water source. So we have no clue as to what kind of geographic impact that may have had on our water just due to climate crisis. Our water levels are lower. So we really need to begin to protect our water sources. And we were really disappointed with the response from NMED as well, in terms of really not doing any investigation to see what the impacts would have been on that. And then again, having gravel or these kinds of industries happening so close to our water sources are very irresponsible, considering just the fact of that we have all the drought issues that we have in New Mexico. So wanted to really talk about that, and I know that oftentimes NMAD is not well funded, but besides that, there is the Constitution basically directs the Environment Department in the state to protect our environment and the health of our people. So once again, support the folks from our western part of the county. We're on the eastern part of the county in Wagon Mountain, but again, we're very concerned about our water access. Thank you very much.
Thank you, Ms. Martinez. Pam, who's next?
Paula Jean.
Paula Jean, can you unmute yourself?
Hello.
Hello. You are
Okay,
echoing.
something's.
Ms. Jean, you're echoing. Can you turn off?
I know. There, is that better?
No. Are you logged in twice, perhaps?
Can you hear me now?
Yes, that's much better. Thank you. Would you
Okay, yeah.
spell your last name, please?
Last name is Jean, Jeane.
Thank you. Do you swear or affirm to tell the truth?
Yes, I do.
I will start your 3 minutes.
I live at 235 Rio de la Casa on the property of my landlords, the Colemans. And I believe it was Sunday, December 1st and Tuesday the 3rd that we had very windy days. Sunday, I coughed a lot, as did my landlords. The wife coughed all night. We weren't sick with a cold or anything. So I sent a complaint to air quality control and got back a phone call from a man. But I can't find my notes on which day or his name. I asked a lot of questions and realized there was not much he could do. He wasn't in charge of measuring any particulates in the air, for example, but could just go by the site and see whatever he could see. After that conversation, I came to the conclusion that various environmental concerns in New Mexico were addressed separately and didn't seem to work together to establish an overall plan for making sure we have clean air, water, and soil. Number two, I house sat at the Davidsons, the adjacent to the property involved with the crusher, from Sunday, December 8th to Sunday, the 29th. During that time, trucks would come and go in the lot right next to their fence, inches away. On the Sunday before Christmas, I was awakened about 7 a.m. by the sounds of trucks coming and going, loudly beeping as they backed up for almost an hour. They seemed to be dumping piles of gravel or something. And during my stay there, every time I looked towards the crusher property, the sky always looked dusty, never blue, like the sky in the other direction. Also, my nose ran every day, even though I didn't have a cold or feel ill, just clear stuff. Not only that, I would have 2 or 3 very strong sudden sneezes off and on. I believe my body was merely doing its job of clearing out unnatural excess particles from dirty air. Anyway, the crusher operation is bad for the environment. It's bad for the neighbors, peace and quiet. It impacts the nature of a rural setting. People are happier in a clean, quiet environment. I suggest a thorough investigation as to its impact on the air, the acequia, the river, and the soil, and how these aspects interconnect, because in nature they all work together as a system. I suggest it has been illegally pushed upon us. And I've even heard some people have been harassed and are afraid to speak up. Thank you.
Thank you, Ms. Jean. Is there anyone else?
Yes, Jordan Minkin.
Hi, my name is Jordan Minkin. That's JordanMinkin.
Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your 3 minutes.
Okay, thank you. So I live at Hummingbird on Rio La Casa, half of a mile from the crusher operation. I've been here for 6 years. Also, my background has been a general manager, a manager managing some industrial operations, one of which crushed a product similar to pumice, and we emitted crystalline silica and PM 2.5 and VOCs, which I understand this plant is also emitting. What I want to say is I have asthma and reactive airway disorder because of being in an environment that was emitting these pollutants. And I can tell you that it affects one's life permanently. I'm on medication to deal with this. And in fact, I moved here to get away from it. I see dust emitting from the plant, pollutants from the plant regularly when I drive by, which is 3 or more times a week. The valley that I live in is hazy now, and it wasn't before. I also hear the crusher operating a half mile away. I'm very concerned about the people in Cleveland who are even closer to it. Additionally, in Santa Fe, I lived near the pumice plant for 5 years that operated off of St. Francis Road. I was just outside the exclusion zone perimeter, and my house was full of dust daily from that plant. When I went to dig my garden after the plant ran for 40 years or whatever it was, I had 4 inches of pumice debris on my land. So NMED's interpretations of the law from the state of New Mexico, in my opinion, need to be interpreted as strictly as possible, not as loosely as possible in favor of the plant operator. My request is that you set the boundary of the operation, the perimeter of the plant, including what we're calling the annex, set that as the boundary of the operation and measure your exclusion distance from there. Don't make it the crusher itself, because particles are emitted from the entire place. I could go on further, but I won't. But thank you, committee, for hearing all of us.
Thank you, Mr. Minkin. Pam, anyone else from the platform?
Paul Cassidy.
Thank you. My name is Paul Cassidy. I am from Cleveland, New Mexico, aside about 3/8 of a mile from the crusher site on County Road.
Hold on. How do you spell your last name?
Cassidy.
Thank you. Do you swear or affirm to tell the truth?
I do. Thank you.
All right. I'll start your 3 minutes.
All right, great. Let me start over. Madam Hearing Officer and Madam Chair, thank you for the opportunity to speak. I'm Paul Cassidy, and I grew up in early life a quarter of a mile to 3/8 of a mile from the crusher site, and we currently reside there again part-time in that area. I had submitted a letter to Rhonda Romero on May 20th, and I'm just going to recite some of the facts from that letter. The site of the crusher is in an area known as the Rock Pit, in an area that was burned during the Hermit's Peak Calf Canyon fire. The work that has been done to date creates an awful eyesore to the beautiful area in the Mora Valley and Cleveland in particular. This is a residential community, and it now looks industrial. It's noisy and it's dusty, as you've heard prior testimony. The facility is located directly across State Highway 518, across from our 28-acre property separate from our residences, which is at a lower elevation. The Rio de la Casa stream meets the Mora River on this property and has suffered much flood damage already. We have concern that future flooding might impact our property. But now with runoff, environmental contaminants, whatever they might be, and we don't understand what they might be yet, from the crusher and mining operation in the future, we understand portions of this area of the valley is in a floodplain We know it is. I don't know where the exact boundaries are. I don't have the resources to determine that. And we would like to really know the facts. That was the purpose of the letter. How can we get more facts? And we appreciate that Mr. Olivas spoke earlier and understand his need to be in business and grow his business. Very much so. There are many residences in the area within a quarter to 3/8 of a mile from the crusher. We have 2 rental properties, small rental properties, the historic family house, the historic Cleveland Roller Mill and Museum, and 2 additional housing units within that 3/8 of a mile boundary. 3 homes are on well water, one which has a shallow well downstream from the crusher and at a lower elevation from the crusher site. What will a flood and runoff impact be to the well and water safety for these homes and the residences currently there? So for that reason, until we get further additional information, we stand in opposition to the permit. In addition, we do not understand how the rock mining facility was originally permitted. The county commission has not been considered, has not been asked to consider it from what I understood, and I'm not altogether clear about where we are on that. But thank you for your consideration, Paul and Connie Cassidy.
Thank you very much, Mr. Cassidy. Pam, anyone else?
I don't have any other names.
All right, sir? Up here, join us at the dais. You would state and spell your name, please.
Hello, everybody. My name is Diego Olivas, Diego. I'm the son of Salomon Olivas.
All right. Do you swear or affirm to tell the truth?
Yes, ma'am.
I'll start your 3 minutes.
First, I'd like to say I'm also a captain with the Chet Fire Department that directly serves this community. So my first problem I have is I have an objection to some of the pictures that were shown up above. As Ms. LaCruz has stated earlier, the New Mexico Supreme Court General Ruling 23-113 allows self-litigation. With that being said, on Senate Bill 167, Section 3, it states a person, state agency, law enforcement agency, or political subdivision of the state shall not use a drone or unmanned aircraft with the intent to gather evidence or other information pertaining to criminal conduct or conduct in violation of a statute or regulation on private property in which the property owners have a reasonable expectation of privacy, which is guaranteed in the 14th Amendment of the United States Constitution. Second off, we never asked for any of this. As a fireman, a tactical decision was made during the Hermit's Peak Canyon fire to backburn our property that allowed protection of the Cordillera and Cleveland communities. My family has operated a trucking company in Mora since 1962, starting with my grandfather, their father. We have provided jobs in the valley since then. As someone stated earlier, the valley has inhabitants that are underserved minorities. This project is a possibility of creating new jobs within our community, all while serving the interests of the local government, providing the necessary materials to reconstruct county roads from flooding from the burn scar, allowing the necessary emergency resources to adequately serve our communities that each and every one of these people in this room that oppose us enjoy. Thank you.
Thank you, Mr. Olivas. I understand Antonio Esposito is on the platform and would like to offer comment.
Hello, yes. My name is Antonio Esposito. My last name is spelled Esposito.
Do you swear or affirm to tell the truth?
I do.
Okay, I'll start your 3 minutes.
Thank you. I am a registered professional engineer in the state of New Mexico. I also represent 2 landowners, one of which is adjacent to the property owned by the Olivases. Both of these properties are within a half mile of the gravel pit. Both of them do have groundwater wells that have been used in the past. My family, who I am representing here, have had property in this valley and in this location for well over 100 years. I would like to just let everyone know that the Olivases have never reached out to my family to talk about what their intended use of the property was for prior to starting any of this gravel operation. They have not acted in good faith with the county or with the neighbors in the area. Rancho Escondido stated in their application for a permit from the county that they were just doing site remediation from the fire that was started, which also affected my property as well. PG Enterprises, on the other side of the coin, is a for-profit company looking to maximize their profit. They're not looking at remediation of the site. Second, neither PG Enterprises nor Rancho Escondido have been in compliance with the permits that have been issued to them to date. They have not been covering the haul roads with water control. They have not been providing dust control mitigation that is a requirement of their permit. And the state has not provided adequate oversight to confirm that they are doing what they need to be doing. Third, they waited until November, 3 months after they received permission from the state for air quality permit only, not for working the gravel pit, to get a commercial driveway permit along Highway 518. Since they received permission to have this driveway, they have not been in compliance with that permit either to install the necessary mitigations and adjustments to the gate or the vehicle tracking control to stop any soil from tracking onto the highway. Additionally, they have not been in compliance with the stormwater protection requirements that the state has with the EPA. They have not applied for a permit for a stormwater pollution prevention permit. They have not provided any BMPs, which are necessary to keep dust control down, which are separate from the air quality controls requirements. They have not provided any kind of protections to the acequia to protect it during a storm event from any runoff or erosion from their stockpiles entering the acequias and clogging them. We have had flooding from the upstream area, which is the subject property, affecting us as well as the properties adjacent to us. And I would really like...
Mr. Esposito, would you wrap up, please?
Thank you. I would really like the board to rescind their permit or revoke it at this time.
Right. Thank you very much. Pam, anyone else?
No.
All right. Again, this is not the last opportunity for public comment, but if you'd like to come up now. Would state and spell your name.
Gabrielle Olivas, Gabrielle. Olivas.
Thank you. Do you swear or affirm to tell the truth?
Yes.
I'll start your 3 minutes.
So thank you all for hearing what everybody has to say today. I'm going to come to you on a little bit more of a personal level. I really appreciate a lot of what we have learned, not just today, but from the environmental department over the past few months. From our neighbors, from our community. I've actually learned of a lot of neighbors that we have in Cleveland that I never knew. I was born and raised in Cleveland. I currently live, or I've always lived, about half a mile from the crushing site. I pass by this area at least 4 times a day. On occasion, I'll drive in to take my family lunch or whatever it might be. And I can see all of the concerns, and I agree. If there's anybody that can tell you how important it is, the water, our breathing quality, the history of our town, of our community, I can attest to that. I have a heart condition right now, and so being safe following proper protocol um, our within the operation is important to me, but I also have all of my loved ones that are there. For us, it's much deeper than just a business. This is not a get rich kind of scheme. We're here, we're part of this community. It's our community. We've lived here our entire lives. I'm 36 years old, and I don't know anything else besides Cleveland as my home. We're also here to give back to our community. If you need help with your acequia, our guys are the first ones to help you out and clean that out for you. If you need culverts, we're here for you. There's a lot of people that were affected by the fire. I've had a lot of my cousins, my brothers, with our equipment, helping our neighbors, one another. We're not here to take from anybody. We live in this community too. It matters to us too. The air quality matters to us. The water matters to us. That is why we are here, to make sure we are doing this properly. But all we do, we're constantly giving back to our community. And even if you look at it from a business standpoint, the revenue that we will produce from this gravel pit will come back to Mora County, which is huge for our poor community, for our poor roadways. We're contributing to our community in a positive way, and that's what we want to do. We've always been here. We live here currently. My children are 10 and 6. They live here, and we will continue forward. I don't want any of the same things for my water or any of that either. I'm living in it too. I'm here too. And I thank you for your concern. That's what we're here to do it the right way. Thank you.
Thank you, Ms. Olivas. Anyone else? No? Again, it's not the final opportunity to offer public comment. I'll invite it again later this afternoon. So let's return to Mr. Martinez. Rejoin us at the dais. I believe Ms. LaCruz Crawford has additional questions of you before we turn to your cross-examination.
All right, thank you. I appreciated getting to hear all that public comment. Very helpful, I think. I'm just going to cover a couple things that I missed before when we were talking. So one is, how many properties are served by the acequia, or how many presiantes, whatever is the easier question to answer?
Yeah, there's about 80 various parcels of land, some owned by the same owner.
Okay, and you had stated in your prior testimony that you did a walkthrough of the property with Mr. Chudnoff. Is that correct?
That's correct.
Do you know when that happened?
It is the day, let's see, I can get the date off the photographs that we took of the acequia, but I don't remember that day.
Okay.
It was in the early days of the operation.
Okay, hold on just a second. So I'm pulling up exhibit 4. If I recall correctly, is this the photograph?
That's correct.
Okay.
That's the day that we went through the acequia.
Okay, and then I believe you had testified that you had also been there another time prior. Or was it prior or after?
We had been there several times before and several times after.
Okay. All right. So I just wanted to ask you, and actually we can look at these pictures. So just looking at the photographs that are in this exhibit, when we're talking about flooding, where is the flooding coming from? In which direction? Say this is the second page.
The entire acequia is part of the flood zone. If you look at the Mora map for the flood zone, it basically encases both sides of the acequia for a width about maybe 10, 15 feet on both sides.
Okay. And so does the debris make it into the acequia?
Oh, yes.
Okay. And is it coming in from one side more than the other?
It depends on the acequia, how it is sloped. Some areas are real steep banks. The others are gradual banks.
Okay,
And
let's just talk about what we see in the photo here. So where would the debris be coming from
on both sides.
on both sides?
Yes.
Okay. And you had also previously testified that you do use large vehicles and equipment to be able to clean up the acequia. Is that correct?
That's correct.
And do you feel that having some sort of an offset for any site operations from the acequia would be beneficial, say, just for instance, if it-
Objection asked and answered.
Ms. LaCruz Crawford, I thought you had covered this before lunch.
I could have, but essentially, I don't recall whether I asked this particular question. I can rephrase just slightly just to say, so I had asked, I believe, about whether a 67-meter setback from the acequia would be beneficial. What I'm asking about now is whether the operations, the area of operations here from the actual site should have some sort of additional offset from the acequia so that they can get in there and do maintenance. So that's what I'm trying to get at.
All right, let's keep going then. Go ahead, Mr. Martinez.
All right, so I believe, just to rephrase the question, do you believe that having an additional offset or setback, maybe like 50 feet from the center of the ditch, would be sufficient to allow you to get in there and clear debris without materials from the site coming into the acequia?
Yes, and if I may add a just small statement, we have in our bylaws a stipulation that says that whatever area or width is necessary for us to get in and do the work is our easement. We don't stipulate a specific distance, so that if 50 feet is a number that we want to establish, that would be fine.
And to your knowledge, and if you don't know, you don't have to answer this, but is that compliant with the New Mexico state statutory provisions pertaining to the
Objections asking the witness to come to a legal conclusion.
Right. So
Okay.
we do have to avoid that, Ms.
I will withdraw that question. Okay. Just one other question. Is the acequia, am I correct that it's a political subdivision of the state?
That's correct.
Okay. So that acequia is operating in accordance with its bylaws and the New Mexico state statutory provisions pertaining to acequias. Is that correct?
Correct.
Okay. Was the acequia involved in protesting the? Oh no, I asked this too. Oh yeah. So you had stated that the acequia was involved in protesting a prior application by Rancho Escondido for a general construction permit. Is that correct?
That's correct.
Okay. And why did you oppose that application?
Well, we knew that this was going on, and through the Freedom of Information Act, we got the permit and reviewed it and realized that it was very close to the acequia. So I wrote a letter to the Air Quality Bureau at that time. And unfortunately, our acequia did not have an email. So I sent the email via U.S. Postal Service and submitted that to the Air Quality Bureau on that original permit.
Hey, do you find it confusing that there was a
Objection, leading question.
Yeah.
Okay.
Can you explore this without?
Okay. Let me think of how to rephrase. So, how did you feel about the fact that two separate applications were filed pertaining to this same parcel of property? One right after the other.
Well, originally I quite couldn't understand why if you applied for a permit and you failed, you would try to use another approach to get through to the permit. When you fail that one, then you would go to another process of trying to get the permit, which is this relocation permit. So it bothered me to realize that that was happening. So in my mind, it confused me why it was happening that way, and it brought me here. I'm here today representing the acequia because I couldn't understand that a process that would fail in one way would succeed in another for the same purpose. So it disturbed me.
Okay. Do you think that were you or people you knew less willing to participate in this proceeding initially because there had already been a denial issued by the Air Quality Bureau?
And please just answer for yourself, Mr. Martinez.
Repeat the question, please.
Were you less willing or engaged in this proceeding at the onset because there had already been a denial issued?
Asked and answered. He just answered the question. He said that's why he was here.
Right. Ms. Lickers, this is becoming less helpful, I think.
Okay. So I have 3 questions about the posted notice. So when did you first become aware that there was a new application filed by PGE?
When Ms. Stalin sent me the permit via email.
Okay. And did you ever drive past the site?
Yes, I did.
And did you notice what the public notice looked like?
Yes. And I mentioned this, that it was not visible very well. If you were headed west to east, you could see it. If you went west to east, you could see it if you were looking for it.
And I think, could you clarify your previous statement? Because I think you may have said the same thing 2 times. So when you were driving, which direction could you see it?
You could see it if you were driving from east to west.
Okay. And you could not see it if you were going the opposite direction.
That's
Is that
correct.
correct? Okay. All right. That's all I've got. So thank you.
Thank you, Ms.
Thank you.
Crawford.
Thank you.
And Mr. Martinez,
Yes.
we have a number of people who might want to ask you questions.
Okay.
We'll start with Mr. Behill.
Thank you. Thank you. Mr. Martinez.
Yes.
Have you ever had a problem with the Olivas family allowing access to the property?
Never.
Excuse me?
Never.
Never. And you've never, you or the Acequia Association has never been denied access to your knowledge?
Correct. They have never been denied.
Have they been forthcoming in terms of providing labor, to your knowledge, with regard to cleaning the ditch? In other words, have the Olivas family helped clean the ditch and help maintain the ditch when necessary?
Yes.
Have you or anyone in the Acequia Association that you represent been kept in? Maybe I'm repeating myself, from entering the land?
No, we've always entered.
You always have. Okay, thank you so much. And now you mentioned earlier that NRCS had installed some culverts for purposes of flood control. Why would, well, first of all, do you think that was a good idea that they did that?
They have not done that, but they are planning to install.
They're planning to install it. Do you think that's a good plan?
Yes.
Why so? Why is it a good plan?
Because it removes the process of cleaning the acequia every time it rains.
I see. So, am I correct, or is it correct that the installation of culverts can protect the acequia in some regard from say any type of excessive mud or anything like that?
Yes, in the area where they are being installed, yes.
Okay, thank you so much. Now you were talking about, you had said that a 50-foot a setback between the area of operations and the acequia might be a good idea. in order to do ditch maintenance. Is that correct?
Yes.
Okay. Do you have any idea off the top of your head, ballpark, if you're comfortable with how long is the Caterpillar equipment that you were talking about? Do you know how big that is?
Yes, a 308 Caterpillar Traco, yes. It's basically 5 foot wide on the base.
It's how wide?
The tracks are 5 to 6 feet wide.
Oh, it's 5 to 6 feet
Yeah,
wide.
on the
Do you know
track.
how long it is?
Yes, it's got, well, I don't know that,
Okay.
but it's,
Is it under 50?
okay.
Is it under 50 feet
Yes,
long?
it is.
Do you think it's under 25 feet long?
Yeah, the total length would be about 25 feet. Yes, like from here to the wall.
Oh, okay. Gotcha. Okay. Thank you so much. Give me a few minutes here. A lot of questions. I have no further questions. Thank you.
Thank you, Mr. V. Hill. Dr. Sinclair, do you have questions of Mr. Martinez? You do? Okay, we need you to come to a microphone. Let's see here. Could you? Oh, great.
Here's one here. Yes, Ms. Martinez, just a couple of questions. Don't want to repeat yourself. To your knowledge, is there a right for pacientes or commissioners to take water from the ditch?
Is there
Yes, a right. To your knowledge, is there a right for pacientes or commissioners to take water from the ditch?
Objection. This is not within the scope of his testimony.
Well, I have a second question that's connected to it that relates directly to the testimony.
All right. And would you please spell paciente for the transfer?
PARCIENTE.
Thank you. Go ahead.
Should I ask the question again?
Ms. Martinez, do you understand the question?
Yes, ask it, please.
Yeah, to your knowledge, is there a right for pacientes or commissioners to take water from the ditch?
The area in question has never been watered, so the land has no ditch rights. They have ditch rights to the second branch, the Alto branch, so they can water areas that have been watered in the past. But right now, they have not requested transferring water rights or anything, but they have no ditch rights.
Okay, so furthermore, to clarify on that question, to your knowledge, is there a right to take water from the ditch for commercial use?
No, the bylaws stipulate that water from the acequia cannot be used for commercial use.
Thank you. That's my questions.
Thank you, Dr. Sinclair. Let's see, Mr. Maxwell, do you have questions of Mr. Martinez? Go ahead.
Yes. 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 And I can explain that if you need me to. The public notice was posted on the tree. The tree was up against the fence, the highway fence. If you drove east to west, you're driving on the right side of the road and you see the sign or the public notice on the side of the tree facing toward the east, not up against not toward the highway. If you came back going west to east, the public notice would be hidden and you're also a lot closer to the tree where the public notice was posted. And that time that you had to see the notice was a lot shorter than when you approached it. If you can envision that. There had been previous postings, I believe, when Rancho Escondido was trying to get their permits. So I was already looking for things there, but she made me aware when PG Enterprise requested the permit. I became more aware of the setting.
Thank you, Mr. Maxwell. Let's see. We turn then to the board, I believe. I'll start with Member Garcia.
No questions. Thank you. Thank you for your participation.
Member Hong.
Yes. And I believe you may have covered some of this at the beginning of your testimony, and I just didn't catch it. But what is the source of water for the acequia in question? The Rio de la Casa River. Okay. And so it flows from west to east across the property? The river flows, basically short circuits itself and goes into the Moro River before it comes into the acequias. Yeah, but the acequia that runs through the property of the rock pressure flows from west to east. Okay. From west to east. Thank you. That just helps me understand the situation. Thanks.
Thank you. Vice Chair Trujillo.
Oh, yes, and I just want to understand a little bit more about the Acequia Commission.
Sorry, would you please? Thank you.
So just can you just help me understand the setup for it? Are you a commissioner for the New Mexico Acequia Commission?
No, for the local acequia association.
Okay.
The New Mexico Association is a statewide organization that helps us govern our acequias by providing support, by providing us information on how to do bylaws. They guide us. It's a New Mexico organization that sits within Santa Fe. Our association is a private organization that we govern the operation of the acequia through our own board and basically have our own bylaws and our own banking and our own EIN number, and basically elect and follow the protocol of the Open Meetings Act and all those other things as well.
And do you frequently comment on permits of any kind for operations that are near acequias?
We have never had to do that.
Oh, okay. You mentioned bylaws and governing. So I'm curious if there's how you deal with enforcement of those bylaws, or maintaining that governorship over your designated area.
It has been difficult. Enforcement has always been difficult because there are sometimes parciantes that are fighting with the neighbor, and they bring the acequia in to try to help. So we try to do it as neighborly as we can. And that's been our approach is as we look at things, we try to work together and hope that solves it. And some issues we can't solve and they just linger on through life.
Well, thank you for your time.
Thank you.
Thank you. Member Ely?
Yes, I do have a few questions. Thank you, Mr. Martinez, for being here today and providing your testimony. It's very helpful. I think you stated that it was the Martinez branch of the acequia that was closest to the point of operation. Is that correct?
That's correct.
And that is also the branch that has maybe had the most issues with flooding in the past and debris in which, was it last year you had to clean it out maybe 13 times?
Yes. Well, there was 3 major events, and we walked the area this last year 13 times for various reasons.
So you needed access 13 times, and
This last year, yes.
did you do maintenance each of those times?
Yes, we did.
Okay.
Some were maintenance, some were, as I mentioned before, observations of the state of the acequia, evaluations by FEMA in an effort to try to help us, a multitude of reasons.
And during those, the timing of those 13 visits, that was between spring and fall primarily?
Correct.
So over 6 months, maybe you had to visit the site twice a month or so?
Yes.
So it may be better in the future with the NRCS project. We don't know yet. They're going to start in the spring.
Correct.
But it seems like frequent access has been required. And I've noted, you've noted, the attorney has noted the new condition number 9 that would require operations to cease while maintenance was being conducted. Have you seen that?
Yes, I have.
Requirement. So my question then is, has there been any discussion about how to communicate with the Olivas when you need to be on site? Have you discussed the system or put a system in place so that there is not access when it's operating and you do have access only when the facility is shut down?
We have in the past, I have texted Salomon Olivas to the fact that we're having this happening. And he has always said, okay, but we were not in the state of crushing. They were just in the state of sorting a rock. So yeah, I have done that. I have sent him letters. We have tried to communicate. I have tried to communicate often with him in an attempt to make sure that he is aware, since he is part of the governing board of the acequia. And we invite him to all our meetings and anything that goes on. So we do that, myself or Henry Sanchez. So we have established a method. Whether that I'm okay with that. We have the text that showed that we're doing that, and I will continue to do that.
Okay, thank you. That's all.
Ms. Stanley, you may. Oh, yeah, hold on. Member Garcia.
Thank you. Member Ely's questions triggered another question for me, which is regarding the same issue on the proposed permit condition, the new one that says that they shall not operate during the time the acequia maintenance or improvements were occurring. When you all go to the site to clean up the acequia or whatever you need to do, could you give me an estimate of the time frame it takes for you to do it? Is it hours? I'm sure it depends on what's going on, but at worst, are you there for hours?
Yeah, it is not normally a very long. It's not a long section of acequia, and typically it depends on the number of men that we take up there. And we do this on a two-step process. Somebody goes in and evaluates the situation. We need 3 men to help us. We go get parciantes to come in. Let's go, and we try to make that happen. I'll tell Salomon, hey, we need to be there for a couple, 2 or 3 hours. That's the kind of stuff that happens. So it's not a long period of time, but it is depending on the severity.
Okay.
But it's not days.
Okay, great. Thank you very much.
Mm-hmm.
Okay. Ms. Stanley, if you would come up to this microphone, please.
Thank you. Mr. Martinez, how do you feel that the quarry affects the NRCS work that the acequia is intending to do next spring?
I really don't know that, only because I don't know. The land has been altered, and Salomon can attest to this. The areas in a flood zone, we are changing the way the water flows over the area by the mere fact that it's not going into the acequia now. I don't know. I don't know how. I just have just observation. If we have a big flood event, I can say that I would be concerned that the water flows into the quarry.
Do you feel that the quarry will have a negative effect on the next flood based on the NRCS work that's upcoming?
Objection, speculation.
Right. I think you are inviting speculation.
Okay. Do you feel that the Olivas have been helpful to the Acequia Association?
In the beginning, I believe so. I believe that the Olivas were helpful, and I felt that we would work together on this thing here. I think once the quarry was started, then our interactions were there, but the communication from me to them was there, but from them to me was not.
How many times have you tried to reach the Olivas regarding anything that you need to do where there was no response?
The early days, I wrote letters. When I wrote letters to the Air Quality Bureau, I wrote letters to the Olivas via their representative, and I had no response. And I felt that it was important that we communicate that. In fact, I went to the point of I invited Mr. Olivas to my house with the other mayordomo, and we discussed this issue. We discussed the issue. So I've been trying to integrate the process with our desires. And it's been difficult because the acequia has gotten very little feedback from the work that we've done. As I mentioned earlier, either through the county or the planning and zoning. And as a result, we had no, and not only there, but I went forward and looked at the New Mexico Acequia Association, the Legal Aid Society, the the state engineer's office. We've worked with all of them, but this was not a water issue, but an air issue. They were not willing to work with. So I've reached out with minimal efforts from the other sites to help the acequia.
How many times would you say you've reached out to the Olivas with no response?
In some instances, they were minors, but I would say half a dozen at least. Invitations for meetings, invitations for doing things. So there have been half a dozen that have been unresponsive, but there's been a lot that have been responsive.
And in future, when you need to go to the site, do you feel that you would be contacting Payam Qureshi from PG Enterprises to get permission to go to the site? Or would you be contacting Olivas to get to the site?
Well, I've always contacted Olivas. I've always contacted Salomon, and I would suspect that's what I would be doing.
And why wouldn't you be contacting the permittee to get access to the site?
I know Salomon, but I don't know the P&G people.
Okay, thank you.
Okay. Any reason not to excuse Mr. Martinez? Thank you very much, Mr. Martinez.
Thank you.
Yes. No, I'm sorry. Only parties. So let's see. I believe you have Mr. Chudnoff. Is that correct?
I would like to request a small break for
Certainly,
personal
yeah.
reasons.
looking up there at the clock. Let's come back at 2:30.
Okay, thank you.
All right. So do we have Mr. Chudnoff on the dais there? If you would please state. We are back after a break, back in the transcript. Mr. Chudnoff, would you please state and spell your name for the transcripts?
My name is Mustafa Chudnoff, Mustafa Chudnoff.
Thank you. Do you swear or affirm to tell the truth?
Yes, I do.
Thank you very much. Go ahead. Ms.
Before we start, I'd like to renew my request to voir dire the witness if I could.
Oh, yeah, Ms. LaCruz Crawford, he is giving a form of technical testimony, and we do allow voir dire in that case. Go ahead, Mr. Reed.
Okay, thank you so much. Good morning, Mr. Shaw. What is your occupation?
I'm a consulting water rights environmental scientist.
Okay, thank you. Actually, I'm going to skip over those things. I'm sure you'll cover those on your direct. How many air quality permitting actions have you worked on?
This is my second.
This is your second. Could you tell us about the first?
The first was a small sand and gravel operation located in Abiquiu, Rio Arriba County.
I see. And was that a permitting case?
Yes, it was.
And what was your role in that case?
I was representing my acequia, questioning
I see.
the appropriateness of the location.
I see. And you were an expert witness in that case?
Yes, I was.
You were, and you said that you represented your acequia. Could you talk a little bit about that? I'm not quite sure what that means. Were you retained by the acequia to represent them as an expert witness?
I'm an officer of that acequia and continues to be an officer. And I provided testimony on a pro bono basis, but as an expert in hydrology.
Okay, thank you so much. And did you testify under the guidance of an attorney in that case, or could it be more characterized as public comment?
No, it was formal expert testimony in a water rights proceeding related to the sand and gravel operation.
Okay, thank you so much. And do you have any professional experience? Well, let me ask you a question. I just need to do it. Are you an attorney?
No, I'm not.
Oh, thank you so much. Do you have any professional training or education relating to mental health or behavioral health?
No.
Okay. Do you have any professional training related to diagnosing psychological or emotional trauma?
No.
Okay. And do you have any professional experience or training directly related to water law or water rights adjudications?
Yes.
You do. Could you tell us about that?
Well, I spent a long time. That's the core of my expertise. So I work with all of the acequias in the Chalma Basin, representing their water rights and technical issues in the Aragon adjudication, which is a federal district court adjudication that went through a settlement process that was recently completed. Most of my work involves in representing matters relating to water rights, which often touches on interpretation of statutes and applicable New Mexico code and agency regulations. It's my bread and butter.
Okay, thank you so much. No further questions.
Thank you. Go ahead, Ms. LaCruz Crawford.
All right, thank you. So just to ask a couple more questions, can you tell me about some of your experience that touches on mining operations?
Beginning in 1984, for a period of 1 year, I was an employee of the Pima County Flood Control District, which encompasses eastern Pima County, southern Arizona. And one of my responsibilities was inspecting sand and gravel operations located within regulatory floodplains and floodways. More recently, I was going in chronological order. I participated in an effort by Rio Arriba County to bring operators and environmental groups together to develop an ordinance for sand and gravel mining. I was the principal author of the ordinance that was ultimately adopted by Rio Arriba County, and that looked at all aspects of mining operations, including setback requirements, compliance with other environmental regulations, whether light, noise, air quality, water quality. Subsequent to that effort, which was very successful, I was retained by Rio Arriba County to inspect a number of operations that were grandfathered in under the new ordinance. I was also retained by environmental groups concerned with how some of these grandfathered operations were operating. And I was also retained by a number of operators to assist them through their permitting in Rio Arriba County and also Doña Ana County.
Okay, and what direct experience do you have with regard to either interpreting or creating regulations that you haven't already mentioned?
Well, I think, as I stated earlier, a lot of my work involves when you're dealing, especially with water rights, you're dealing with property law issues, you're dealing with water rights issues. And even though I'm not trained as an attorney, through my experience, I am usually retained by attorneys to assist them in analyzing legal documents and assisting them in interpretation and application of law, whether statutory or court cases, as well, more often on a daily basis, almost with application of New Mexico Administrative Code.
Okay, and am I correct that, or could you explain your experience regarding working with multiple?
That I've been involved with, including recently, I'll reference one, even though my focus is primarily on water rights, hydrology, including drainage. So my background is not just in water resource development, groundwater resource development, but also I worked for 4 years as a drainage flood control design engineer. So a lot of these projects that I'm involved with, especially the larger ones, are multidisciplinary, where I'm sitting around the table with experts from state agencies involved with other aspects of the project besides water. So for example, a recent project I was involved with about a year and a half ago was the Copper Flats mine application. The proceeding was a water rights proceeding, but to prepare myself for that proceeding, I had to review the record from Mineral Mines Division, surface water quality, groundwater quality, US EPA, and other entities that are involved in permitting mining operations. And I think the biggest takeaway is that, first of all, a multidisciplinary approach and a cooperative approach with other regulatory entities is required, but also the permitting order is critical. For example, what comes first, a land use permit or air quality permit, your water rights permit? What's the order that, you know, these complex projects or even simpler projects, what's the appropriate order that we should go through to ensure that all concerns relating to public health, welfare, safety, protecting water, protecting the environment, that all of those are addressed in an efficient manner.
All right. Have you ever been involved in any case where you've been qualified as an expert to take measurements or interpret aerial photography?
Yes, I would say a significant number of my projects involve the use of interpretation of aerial photography and superimposing, laying out measurements, overlaying plat maps, property boundary maps on water maps and so forth. It's a regular function of my work.
All right. So now I'm going to move past your qualifications unless there's any objection. All right, and go into your report. So just for reference for the board, I'd just like to mention this is SACIA Exhibit 10 in the administrative record and also in our, I think it was just provided as part of our disclosures for today. Can you tell me a little bit about this project and your review of this project?
I was asked by the Acequia del Alto y de los Martinez to come in and work on their behalf to evaluate some of the predecessor applications that we heard about earlier through testimony. There was a previous application by another entity, I believe, that's controlled by Olivas. They had a previous application. I was asked to come in and review that. Initially, the work, my review work was in the context of looking at the application in the context of Mora County's land use zoning regulations. And then as the project evolved and PGE is now the applicant permittee, then my work continued into evaluating their application as well.
Okay, and can you tell me, I'm gonna go through your report. So the first thing you have in your report here is that this is not an attack on the underlying NSR permit. Can you explain what you mean by that?
Yeah, but it's my understanding that the underlying permit has been issued. It's a final permit, basically what we would call a non-appealable permit, and I understand that. And that permit had to go through all sorts of hoops to get approved, and that pertains to the underlying PGE permit for their Rio Rancho location. So I'm not, other than to acquaint myself with the basis for some of the conditions of approval as a necessary element for my review. I'm not questioning the department's work and its ultimate conclusions and permit that are issued. My focus here is really on the current relocation permit and the issues that it raises in the context of Mora County and the Cleveland community.
Okay. So with regard to the regulatory authority of the Environmental Improvement Board, is it your understanding that the department may specify conditions to any permit, any new permit that is granted, and would that apply to a relocation permit?
Well, new permit and relocation permit are two different things, but they both involve permit conditions, which certainly it's within the scope of the authority of the department and ultimately the board to determine what those permits are, or as you know, through the relocation process, if some of the permits conditions have to be tweaked or modified or augmented to address the site-specific conditions that the relocated to, then it's certainly within the scope of the department to apply those conditions.
Okay, and I know that at the time that you provided this report, permit condition number 9 was not yet in place. I just wanted to ask whether you are aware that the department actually did issue an additional permit condition pertaining to this particular permit.
Yes, I'm familiar with that action and I've reviewed that condition number 9.
Okay. Would you say that that is evidence for the fact that the Bureau has the authority to issue conditions relevant to aspects that need to be considered that are different from the original conditions that were existing at the site.
Objection. She's asking the witness to make a legal conclusion.
Yeah, to the extent, to that extent, the objection is sustained.
Okay, so let me rephrase. Is it within the authority of the board and the Bureau?
Objection. She's asking for a legal conclusion.
Again.
Okay.
You
Okay.
can make your legal arguments yourself.
Okay. All right. So can you tell me whether you made any specific findings pertaining to emissions under the permit?
I did not execute an air quality model. I did not calculate emissions or the dispersion of those emissions. If that's what your question is.
Okay, and what is your understanding of the situation with regard to your item number 3, which states that RE 058661 is co-located, I'm getting very tongue-tied, it was put in the day, with an unpermitted operation.
Yeah, I think this is probably the core element of my report and analysis and general concerns with how the relocation permit was issued. I'm familiar with the project site. I've been to the project site. I'm aware that there was extensive land disturbance that was undertaken. My understanding it by Mr. Olivas and his employees, all in preparation, in direct preparation for the installation of the crusher. And all of these land disturbance activities, including clearing of vegetation, grading of roads, construction of equipment pads, the excavation of the pit, creating materials, stockpiles, all activities integral to the operation of the crusher took place prior to the application by PGE. And it's my understanding of how these activities should proceed is if you're going to be creating ground disturbance greater than an acre, then you could trigger the need for all sorts of, and in the context of preparing this for what ultimately is an air quality permit for a crusher, that all of those preparatory activities need to also be covered by various permits, whether EPA permits relating to stormwater management or air quality, because again, you're creating, you're clearing the land, you're exposing it to wind and airborne emissions, you're creating stockpiles. All of that work in the normal course would require its own permit. If it's not part of the relocation permit, then it begs the question of, what I would interpret as these are co-located activities that if they're not part of the relocation permit, then they need their own separate permit. And I've seen no evidence that a co-location permit is being sought for by Mr. Olivas, and I think that's problematic.
Okay, and that said, am I correct that it is based on the previously filed testimony provided by the Air Quality Bureau that it's their experts' opinion that this should just be considered on the sole basis of the air quality standards and the existing setbacks, in the original permit and that there should be no consideration whatsoever of any other impacts that may be occurring at the site.
I think in terms of the work by staff, this is probably the one area that I think they fell short is by their analysis was focused on emissions primarily generated by the engine associated with the crusher. They do address fugitive dust created by other heavy equipment operating in the area, the conveyor belts, the truck traffic, and so forth. But they really don't incorporate all of the other ongoing activities that take place in a larger area that are directly associated and under the control of Mr. Olivas. So I'll leave it to staff to answer that question. But I did not see any evidence where all these other activities that generate fugitive noise, generate emissions associated with diesel engines, whether that was incorporated into the calculations that they undertook to ensure that the total emission load generated from all activities on the site met standards. It may turn out that 67 meters is appropriate, but at least I think staff needs to go through and look at the cumulative impacts of all other activities. I know they looked at where the nearest boundaries are to wild protected areas. They looked at other industrial activities in the area, but all those activities that they enumerated and that are tabulated in their staff reports, there's no discussion whatsoever of all the other activities and ground disturbances directly related to industrial activities by Mr. Olivas immediately adjacent to the rock crusher. And I think that's an omission, no pun intended, on the part of staff.
Okay. And with regard to, you make a statement here that you visited the project site as part of your assessment of this co-located, unpermitted operation that you assert is occurring at the property. Can you tell me what some of your site observations were that support that?
So I went on site during the summer of 2024, accompanied by two of the commissioners of the acequia. We walked along the alignment of the acequia from the, I guess, east property boundary along its length to approximately where the culvert was installed across the acequia. I also walked along the edge of the fill dirt, the heavy equipment pad that was constructed by the property owner. That was sort of the focus. I also looked at aerial photography and other photography provided by my client.
Okay, and when you visited the site, was it your impression that there were one or multiple entities operating equipment on that site?
It's my understanding that there were two entities operating. What their relationship with each other, I don't know, but there was one operator in the final stages of removing burnt trees that were cut down, and that was at the, trying to get my geography here, south, I guess, far end of the property in the vicinity of the other acequia. So there's one operator that was removing logs, and then there was also industrial activities, excavation, stockpiling of materials, screening of rock material that were actively taking place around the area that's where the pit
Do you know
is
who
located.
was conducting the screening?
This is information provided by my client, but I was told that it's an entity. I use the term very loosely. Olivas, whether in what business capacity, I'm not sure.
Okay, all right. You state that it's your opinion that the property is operated as a source that emits air contaminants. And that you had discussions with Mr. Mashburn about the facility. Can you explain what some of those conversations were?
Yeah, it was a brief email exchange followed by a telephonic discussion. This took place during it's a 10-day window in which comment could be provided while the department's still in the process of writing the permit. And the focus of my discussion was on, given all of these ongoing industrial activities closely associated with the proposed crushing operation, why Mr. Olivas isn't added as a co-permittee for this specific relocation permit. And I brought up my concerns that all these activities are taking place. And if Mr. Olivas is not a co-permittee, then how can he be held uh, to any of the conditions of approval that the department is proposing? If he's not a co-permittee, then he has no legal obligations to comply with the conditions of the permit. It's really PG. And we had a discussion back and forth. Well, there are multiple entities running trucks.
Objection. This is hearsay.
Oh, you're talking about your discussion with Mr. Mashburn?
Yes, I'm restricting myself
Go
between experts.
Go ahead.
So my discussion with Mr. I gave him some examples. Well, there are multiple entities running heavy trucks through the property. The proposed permit has a limit on the number of trucks that can egress per hour and per day. But if Mr. Olivas is out there running his own trucks, how do we manage these activities? And it was my takeaway from Mr. Mashburn. It's, well, if PGE is the permit holder, then regardless of whose trucks are going back and forth, that truck count gets counted against the total truck count that PGE would have. Similarly with dust suppression requirements, a lot of dust generated out there could be by trucks being operated by Olivas, maybe related to the screening operation, relating to excavation. Where's the obligation to suppress the dust? Well, PGE, regardless of whether it's Mr. Olivas or a third party out there generating dust, it's PGE that's ultimately responsible for suppressing that dust. And then there's another area, I'm not sure if we discussed that specifically or not. I believe so, but the nature of the PG operation, it's a relocation permit. We all understand based on statements in writing and follow-up email between staff and PGE's consultant is that this is a temporary operation. It's specific, it's tied to a specific DOT project. And according to PGE's expert, he's on record saying that subject only to whether this is a 4-month project. Now, I know the department's a little lenient in terms of whether the permit will terminate 4 months or it's really an open-ended permit until they come in with another relocation permit. But given that, all of the statements on the record, because don't forget, Mr. Olivas has previously filed applications. He's also filed applications with the zoning or the land, the development office with Moore County, all of which are reviewed. This is all identified as a temporary project, whether to address reclamation, his own needs for reclamation, or making materials available to be hauled off site. It's temporary. I've been involved with sand and gravel operations for more than 20 years. They generate materials piles. They generate waste piles. They generate disturbed areas. There's an open pit. If PGE leaves after 4 months, 5 months, 1 year, the obligation to suppress dust goes with them. What are we supposed to do with an unreclaimed pit, 5, 10, 50, up to 15 acres of disturbed land with no commitments to revegetation, no commitments to reclamation, no commitments to dust suppression, no demonstration that they have a permanent supply of water available? And yes, PG is not on the hook. This relocation permit is not on the hook, but what I believe we are in a position to do here today is to require Mr. Olivas to get his own air quality permit. So we all can be assured that when PGE leaves, we're still in a place where dust will be suppressed and other environmental impacts, which you're responsible for here today to address and mitigate, that those are all taken care of. So really, I think Mr. Olivas either needs to be a co-permittee or before PGE can proceed with his work, Mr. Olivas needs to obtain his own permit with its own conditions of approval that will be successor to whatever continues on that property after PGE moves their equipment.
Okay. Was a very long answer. So what? So I'm going to ask you another question. I think I have about 4 questions for you here. So, maybe 5, 6. I don't know. Okay. So the relocation permit. One of the things that you are arguing in your report as well is that it's non-compliant with applicable setback requirements under the original NSR permit. Is that correct?
Objection. She's asking the witness to make a legal conclusion.
I'm actually asking him what he has argued in his report.
Right. No, and I understand that you have a different interpretation of the setback requirements, but I'm going to let him testify as to his own understanding of setback requirements. Go ahead.
In terms of the 67 meter, I believe 67 meter setback, if it's interpreted from the area, the active area of operation, then where the trucks are parked and where I have to assume maintenance work is done. This is the so-called annex, which is located adjacent, immediately adjacent where the pit and those activities take place. Then that those operations and activities are within the 67 meters.
And so let me ask you a question. Do you feel that it's an obligation for the Bureau and the Environmental Improvement Board to look at this permit in a holistic manner that accounts for actual on-site impacts?
Objection. This is asking for a legal conclusion.
So, Mr. Mustafa, do you understand that it would be okay for you to answer in a way that does not require legal expertise?
I believe so. You can jump on me if I do stray in my answer.
Okay, so but essentially I'm just asking, do you feel that the permit should be conditioned on a setback requirement that doesn't account for what's happening on the ground in the real true reality and real life situation for local residents in terms of how close they really are to the emissions?
I think it's from a technical perspective, if you're concerned with emissions, whether they're generated by engines or generated fugitive type emissions created through generation of dust, and then you have to look at all of the activities associated with the site, not just focus on a single engine and where it's located.
All right, and okay. Your next opinion here is pertaining to, you say that the permit should be denied back based on a lack of proper site control by PGE. Can you explain your testimony?
I'm sorry, where are we?
I'm sorry, it would be number 5.
Page 5 or number 5?
Number 5 on page 4.
Okay, and can you, which bullet are we?
Just the first bullet.
Acequias?
Well, you can go. I'm asking you to kind of summarize why you're saying that there's a lack of proper site control by PGE.
Well, again, the majority, with the possible exception of who pushes the buttons and levers on the crusher equipment, who turns on the engine on and off, everything else happening on that side is under the direct control of Mr. Olivas and his agents. PGE has a very small role in this entire operation.
Okay, and you also talk here about a 50-foot on either side of the acequia. You say 50 feet on either side of the acequia is needed to provide adequate access for personnel and equipment and provide a vegetated buffer to trap sediment and other debris. Vegetated buffer to trap sediment and other debris that will be produced by stormwater running off the site. Can you explain why you have reached that conclusion?
Well, it's my professional opinion. I don't know if maybe this is a good time if we can bring up one of those photographs that show the acequia. I don't know if it was figure 1 of.
Were you talking about exhibit 4? Okay, let me get that. This is exhibit 8. I'm afraid this is the same exhibit again. So, there we go. You know, once you minimize how you get it back. There we go. Okay. There it is. Voila. Okay. So is this the document you're talking about?
Yes, is there a way to enlarge that maybe, or?
I can try. So no, I don't think I can enlarge it. So.
Okay. I think, and I'll try to address. No, that's not. Let's go back to that original. You've cut off too much. Okay. So let's talk about what we see here. So there's that bright green line of vegetation. That's vegetation that's growing along both banks of the acequia. And if you look to the bottom left corner, you can see water was running through the acequia. To the left is the heavy equipment pad on which now the crusher has been situated off in an area off to the left that you can see. So that is fill material that was brought in. And if you were to stand right next to the corner, the bottom left corner of the photo, really there would be no room for you to stand between the edge of the acequia and the toe of that fill. And that's loose material that is eroding and washing into the acequia. Off to the right, you see a debris field that is something that continuously is washing down.
Let me ask you a question before you go into the debris field. So, would you say that materials from the crusher would be part of the materials that are going into the acequia at this location?
Well, there's that potential, but at this time, when I was out there, there were no stockpiles from the crusher yet. The crusher had not been located to the site, and the materials stockpiles were off at a greater distance. So at that time, there was no imminent danger of stockpiles washing into the acequia. We'll see in a later photo that there are erosion associated with the roadway culvert that was installed. There's active erosion and sediment washing into the acequia as a result of that work.
Okay, but given the current and existing location of the crusher, would you say that fine particulate matter coming off the crusher could wash into the acequia, or do you think that that's not a realistic possibility?
It's possible depending on where they're located. Combination of factors: where they're located, the height, and the slope of the materials. Piles are all factors to take into account. But definitely, we would need to establish setbacks between where materials, whether it's the spoils or the marketable material, regardless, topsoil, there need to be established setbacks for all of those.
Okay, and I'll let you get to your, I'll ask you to go ahead and testify about this photograph. But before we do, I did want to ask, were you present for the testimony earlier today by Ed Martinez regarding a request for a 67-meter setback from the acequia?
Yes, I believe so, right.
Okay, and do you have an opinion concerning whether that would be protective of the acequia's interests, considering how often they need to be able to go in to access this site?
Well, the purpose of that setback, the 67 meter setback, is to protect personnel and also mitigate against exposure of unhealthful emissions. So that's separate from the setbacks I'm talking about.
I do understand. So that would be an additional setback. Okay.
Correct.
All right. Thank you for that clarification. All right. Go ahead and explain what you're seeing in this photo. Or what you...
Okay. So what we're seeing to the right, which is also topographically up gradient, is a debris field. So this is woody material, trash, you name it, that continuously washes down either from other areas within the Olivos tract or from off-site due to stormwater activity. And we've heard also additional testimony today about how that material ends up in the ditch. And I don't know, do you want me to start talking about the purpose of my 50-foot setback, or do you want to
I think
go piece by piece here?
Well, you can. Here's what I was going to ask. So, is there anything additional here that you want to address pertaining to a lack of proper site control that hasn't already been spoken to?
Well, let's talk about the setback, because there was some testimony and also cross-examination about the purpose of the 50 feet. 50 feet. Why did it have to be 50 foot? So we heard some questions. Well, the heavy equipment that you bring in doesn't require 50 feet to maneuver, and that's true. But what we see here is that there's a continuous influx of debris that's going to continue probably for years to come until the burn scar, has a healthy vegetation cover. So every time there's a significant runoff event, the debris that we see here is washed into the ditch. And yes, there are people there available to move it out, but why are we moving it back out and putting it upstream So the next storm event comes and washes it back in. My advice and recommendation to the client is if you had a 50-foot setback as well on the other side, then not only do you have room to maneuver your heavy equipment, you also have a place to drop off all these materials that have fallen into the dish. You're not constantly having to move the same pile of debris from one side to the other. So I think, again, working cooperatively with Mr. Olivas, there's no reason why that embankment, which is sloughing off into the acequia, creating its own problem, why it can't be moved back 50 feet. There's going to be lots of room to stockpile and dispose of all this waste material that's coming down. And I think both the acequia and Mr. Olivas will have all the space they need to carry on their operations.
Okay. So the next section of your report deals with fugitive dust mitigation. Can you explain what the requirements of a permit are for fugitive dust mitigation?
Right. So there's standard conditions of approval in the permit that typically you're required to have spray bars on the or standard is unless the equipment's been modified, it's standard equipment that the crusher assembly, the conveyor belts, the actual crusher, all of those are equipped with spray bars. Typically, in a typical operation, when there's crushing going on, then you're also spraying the materials as it's moved from position to position. There's also dust generated by trucks being loaded and unloaded. There's dust that can be generated by wind blowing on materials piles. And the material piles, there's probably maybe some topsoil piled up that's going to stay there until reclamation, who knows when. There's going to be waste piles of fine material that is not going to be used by the DOT because according to the applicant, they're looking for crushed rock. They don't have to wash the crushed rock, which removes some of the fines, but still, in the normal course of running a crusher, they're very fine particulate material that the Department of Transportation, they don't want to pay by weight or cubic yard. They don't want to pay for that waste product, so that has to be stockpiled. There is also the raw materials piles. All of these piles can generate fugitive dust. There's standard conditions of approval that require that water or other agents be applied as needed to basically minimize the extent to which, first of all, minimize the occurrence of the dust, but then to keep it localized and certainly not to allow it to cross property line. My concern is first, there are two concerns. One is a permanent source of water has not been established. I know there's a temporary 1-year permit that the applicant, not the applicant, but Mr. Olivas has received from the state engineer office, but that's a 1-year permit, and I believe that permit's in the record. But again, PGE is there for only 4 months, 5 months. What happens after that? The waste piles might still be there.
Objection.
Okay.
This has already been covered.
Okay, if you would move on, Ms. LaCruz Crawford.
All right. So I just I wanted to ask you to state your conclusions in terms of and to please explain what permit conditions you would recommend or place on the permit to help to protect the acequia and its members when they, especially when they're coming on to the property to perform maintenance. There is now a existing permit requirement number 9 that asks for the operation to be shut down when they are doing maintenance. But my question is, if that becomes too frequent, in terms of what is needed by the acequia, what other conditions can be placed on the permit instead that might be equally, if not more, protective of the acequia's interest?
Well, establishing the 50-foot setback would certainly help because it does provide a pathway for both personnel and equipment, acequia personnel and equipment. It gives them a safe pathway where they don't have to navigate in between the operating equipment, even if it's idle. Again, my understanding, condition 9, it's shutting off the crusher. The trucks are going back and forth. The bulldozers are going back and forth. So I think condition 9 needs to be, in and of itself, needs to be modified to minimize or eliminate all heavy equipment, all heavy operations, while the acequia personnel are on hand. But again, a lot of that potential for interference between Mr. Oliva's activities and the acequia can be addressed through the 50-foot setback, and then maybe providing the acequia with another way of accessing that 50-foot, where they're not having to share the same entry point that the heavy equipment that's currently not regulated by condition 9. So that potential conflict is eliminated. Really, in my mind, the only way to ensure that there are enforceable protections in place, whether from the acequia's perspective or environment, is to require Mr. Olivas to get his own permit. Otherwise, he's under no legal. I know he's made good effort, extending his hand to the community. I respect that. I think that's very good. But things happen, people change. The bottom line here is when you're writing a permit, who is the entity, who is the individual, which corporation is ultimately responsible here. And if Mr. Olivas is really running the show, then he needs to have his own permit. And that way, if an issue does arise, then the community.
This has already been covered. Objection.
Yeah, I think you're summarizing at this point, Mr. Chudnow. All right. Were you done with your summary?
I think that we are, let me just ask one last question to you. And if you could please make your response brief. I would just ask, so, there has been some testimony that has been provided today about the good faith efforts of the Olivas family. And Solomon Olivas himself to, be a good, to some extent, to be a good neighbor. But I have to ask, has your review of the applicable permits that are required for this site to even exist, have those requirements been met? And does a failure to meet those requirements show a lack of good faith? And so that's my question to you. And with that.
Objection. This is asking for a legal conclusion.
I believe it is in large part Ms. LaCruz Crawford asking for a legal conclusion. But I have certainly appreciated Mr. Chudnow's other testimony.
Okay, can I just ask whether he has, did you do a review to see if he had other permits for the site or any permits to operate this facility?
Yes, I did. I researched the US EPA website. I researched the website and spoke with individuals with the Surface Water, the New Mexico Surface Water Bureau, the Groundwater Quality Bureau, county zoning, all the entities that potentially have some regulatory control, and there's nothing in place.
Okay, thank you.
All right, thank you, Mr. Chudnow and Ms. LaCruz Crawford.
Madam Hearing Officer, may we take a 5-minute recess so I can talk to the clients?
Yes, absolutely. Let's come back at 3:35. All righty. Let's come back from the break, please. Mr. Behill, do you have questions of Mr. Chudnow?
I'm sorry, I didn't hear you. Are you ready for me? Okay, thank you. I'm sorry. Mr. Chidnoff, you spoke about 50-foot setback that would be ideal in your client's view. Earlier, there was some testimony indicating that the 50-foot setback would be good for heavy equipment. You indicated that you didn't necessarily think 50-foot setback was required for that, although it might be nice. Is that correct?
Well, I would, based on my practice and being familiar with my SIC and other SICs, 50 feet for heavy equipment is more than adequate, but I would defer to the percentage, people on the ground operating the equipment, they're swinging their boom around, making sure there's a safety zone all around. My focus really, my testimony was, in addition to having room for equipment, over time, you're going to be building up a pile of debris within that 50 feet. So really, within a year, 2 years, you don't have 50 feet just for equipment. You're going to have less than that. So I think starting with 50 feet, having that 50-foot though as a permanent area for disposal of vegetation and other materials.
I see. Okay, so in other words, the 50-foot, in addition to the equipment, you're thinking that the 50-foot setback would be good for storage of materials that wash down and so on and so forth.
That's correct for both purposes.
Thank you. And I want to be clear, these materials, most of what you're talking about, these are downstream, whether they're on the Olivas property or upstream from the Olivas property. Is that correct?
Didn't catch the first part you said they're downstream.
No, I'm sorry. The material that accumulates that you're talking about, that comes upstream
from upstream.
From an upstream portion of the Olivas property or upstream on other properties. Is that correct?
From further, and I would supplement that, is that with the construction of that equipment, that heavy equipment, dirt pad, that large pad on which the pressure now rests, that actually cut off part of the historic pathway where debris would have washed down. So now it's all being concentrated along the acequia.
And one last question, or one last set of questions. You testified that condition 9 was only with regard to the formal facility itself, the crusher, the engines, and so on and so forth. Where did you derive that conclusion? Did you speak to anyone from the department about that?
No, it's my recollection of the actual language of condition 9. That's what jumped out to me, is it referred to operating of the crusher. I don't know if it referred to all side operations or
yes,
or not.
We'll provide more testimony about that, so I won't do that, of course. But is it fair to say, respectfully, that it's speculation on your part that condition 9 does not refer to the entire facility, including trucks?
I wouldn't say it's speculation. Maybe I didn't read it closely, or it's a question of interpretation. Again, my perspective is a lot of the activities on site are not under control of PGE. They're under control of Mr. Olivas. And condition 9, as it reads, only applies to PGE. They're the permittee.
I see. Well, and now you say that, it brings up another question. You say that the operations are not under control of Mr. Olivas. I thought earlier you said that everything was under the control of Mr. Olivas.
Yeah, most, with the exception of the crusher itself. It's my understanding that all the other side activities are under the direct control of Mr. Olivas, his employees, agents, so forth.
Okay, thank you. I have no further questions.
All right, thank you, Mr. Vigil. Dr. Sinclair, do you have questions of Mr. Machado? Okay, Ms. Tamland? And let me just say, please, Mr. Juno, be careful not to talk over the end of the question or sentence. Thank you.
Yeah. Are you familiar with the maintenance yard?
Yes, I am. What's also been referred to as the annex.
Yeah. Would we be able to look at a photo of that?
I believe it's one of the photographs.
Objection, if this was not covered, this was not covered on direct.
Right.
This
This is an exhibit. It was.
Right. Mr. Behill has made an objection that it was not covered in Mr. Chudnoff's direct, which limits the scope of the questioning. Ms. Stanlin, how does it relate to his direct?
It was an exhibit that was submitted, and Andrea didn't get a chance to show it. So I'm asking if we can show it. It was part of Mustafa's testimony.
It was part of your testimony, Mr. Chudnoff?
It's part of my exhibit report. I did not testify to it, though.
Is it in your narrative?
I believe the photos that I only have a
If it's
partial
in-
set here.
If it's in the written testimony, we would retract our objection.
Right. Okay. Can we show it, John? If it's in his narrative, that's fine.
It's figures 9 and 10, I believe it's. Want me to go through that?
Go ahead.
Oh, I'm sorry. Can I get a little technical support? I'm having trouble pulling this up, and it's giving me a. It's pulling up every other exhibit except for that one. I think I got it. Okay, got it. Okay, there it is.
So there's two images in this. So in your estimation, would you say that the maintenance yard of the quarry is within 67 meters of the fence line?
Are you talking about the yard, or are you talking about specific pieces of equipment? Could you restate your question?
Is the maintenance yard of the quarry within 67 meters of the fence line?
Oh, yeah, they share a common property line.
Is it within 67 meters of the fence?
They share a common property line. Are you asking me if equipment parked on the Olivas, the so-called annex, is within 67?
Yes.
If that's your question, then the answer is yes. I've driven by the site. These photos were provided by others, but I have direct knowledge of the site. And as you drive by the highway, the fence lines and where the equipment's located is fairly obvious.
If you could help me understand how they determine 67 meters as part of this permit. Is it from the perimeter of the area of operations?
It's my understanding that as in terms of how staff has applied the setback, had determined and applied the setback for the purposes of permit conditions, it's 67 meters around the engine of the crusher, not around other point source of emissions.
So no other point source of emissions matter in the 67-meter setback.
It's that's correct. It was only where the engine for the crusher is located is the only determining factor. I mean, I'm going back to my early testimony. They also do look at other general sources of emission in the area that can impact air quality, like are there other industrial yards, other crushers in the general area. So those were taken into account. But in terms of locally, it's only the placement of the engine for the crusher that was taken into account.
And do you think that there should be site-specific air modeling to eliminate all of these setbacks?
I think staff should take a hard look at it. What the outcome is, whatever it'll be, but I think just standing back, there are some differences in terms of topography, geography between Rio Rancho and this location. That again, I would defer to staff. I'd have to defer to staff on that, but certainly wouldn't hurt anybody if they did that.
Okay. The Rancho Escondido application for the general construction 2 measures from the perimeter of the area of operations, which is why that application was denied. So,
Objection, relevance, the application was denied. We're not here on that application.
right. So now we have this application that doesn't, please correct me if I'm wrong, that doesn't use the area of operations at all. Is that correct? The perimeter of the area of operations, I thought needed to be 67 meters. Please.
Objection asked and answered.
Right, and you just explored this with him, Ms. Stanley. Do you have other questions of him?
No.
All right, thank you. Let's see. Mr. Maxwell, do you have questions of this witness? Thank you. We'll turn to the board. Member Ely, do you have questions of Mr. Chudnam?
I do not.
Vice Chair Trujillo?
I do not.
Member Funker?
I do not have any questions.
And Member Garcia?
I do have a couple of brief questions. Thank you for your testimony, sir. You seem to have a lot of experience with a lot of different regulatory agencies and permitting and such. You mentioned that you contacted the Surface Water Quality Bureau. Do you know if they require a stormwater permit for this site?
They do not. They advised me that I would need to work with the EPA through their construction general permit process, which does require a permit here, but the acequia is not a waters of the United States that would fall under NMED regulation.
I see. Thank you. One other question. You mentioned that you walk the site. Is there an issue with the grade of the site so that if water runoff would run towards the acequia? Is that a problem?
It is an issue along the edge of where the fill breaks and drops to the acequia. So that would be the area of active erosion of dirt washing off from the industrial activities area.
Okay. So would a berm built up in front of the acequia be helpful to prevent runoff into the acequia?
Well, that's just another pile of dirt that'll wash into the acequia. That's why establishing that 50-foot setback would address both surface water stormwater runoff from the pad and sediment runoff from the pad. But really, again, without a stormwater pollution prevention plan, we really, again, don't know what the site layout is. So, you know, we need to see more data about where materials are stockpiled, where the equipment is maintained, where fuel and other lubricants are stored and so forth. We don't have any of that, which is really what creates the risk here.
Right. And my understanding is there's no state regulations for sand and gravel operations. Is that correct? In New Mexico, you may or may not know that.
There are regulations in terms of the requirements for registration,
Right.
which Mr. Olivas, this facility has been registered with both the appropriate state and federal agencies, but these are not regulatory in the sense that there's no enforcement or permit conditions that come with that. That's just registration. So that's really the extent of what's out there.
Okay, thank you very much.
Great, thank you. Member Bitzer on the platform, do you have questions of Mr. Chudnoff?
I don't, thank you.
All right, is there any reason not to excuse Mr. Chudnoff? Thank you very much. Oh. Okay. All right. All right, thank you very much.
We get to do rebuttal. We don't have an objection to that if that's.
Thank you. Great. We're going to hear next from John Block. Mr. Block, I believe you're on the platform. I see you in a plaid shirt up there.
Yes, here I am.
Hello, would you please spell your last name?
Bloch.
And John is with an H. Yes?
Yes, that's correct.
All right. Do you swear or affirm to tell the truth?
I do. And could I request
All
that
right.
to share my computer screen?
Pam?
Thank you for.
He would like to share his screen. Hold on, Pam is working on it.
Okay. I appreciate the opportunity to be here today, and I thank you, Madam Chair, and members of the board.
Hold on, Mr. Block.
Yeah.
We're having trouble hearing you.
Okay. Well, I'm about as close to my microphone as I can be. Is that better?
A little bit. It's not quite loud enough.
Well, I've got the volume all the way up.
That's much better.
Oh,
thank you.
Okay. There we go. Let me just crank it up. Basically, what I want to do today is talk about dust. We've been talking a lot about water and acequias, and I believe my testimony will dovetail nicely with Mr. Chudnoff. I apologize for not pronouncing your name correctly, with his testimony. So if I can share, let's see, where are we here?
Madam Hearing Officer, before
Mr. Behill.
Before we get started, the department objects to the inclusion of the entirety of Mr. Block's statement of intent. There's been no resume provided. We have no way to assess. He's giving highly technical testimony. He's giving testimony. He's essentially giving scientific testimony on particulate matter. We have no way of assessing his credentials. You know, I appreciate he's not represented by counsel, so voir dire may not be appropriate, and that's fine with us. But proceed however you want, of course. But I just want to get our objections on the record.
All righty. Mr. Block, before you begin your statement, I want you to understand what Mr. Behill is objecting to, which is that you want to offer testimony about particulate matter and dust, which is a form of technical testimony.
Yes.
And was it timely filed, the technical testimony?
Yeah, we don't have a problem with timely filing or anything like that.
Okay, but it did not include a resume. So I'm going to ask you to speak to your credentials first, and then Mr. Vigil may have questions of you about the education or experience necessary to offer the testimony that you'd like to offer. So please speak to your education and experience.
I'm a trained geologist. I have a master's degree in geology from Washington University in St. Louis. I have a PhD from the University of Calgary in geochemistry, and my area of specialty is the petrology of fine-grained sediments, which most commonly are called shales. Petrology involves the origin and composition of these rocks, and so I have extensive experience with the movement of fine-grained sediment, both by water and wind. And I would argue with Mr. Vigil that the nature of my testimony is not highly technical. This is from scientific literature that almost any layman could read, should they have access to it, and a discussion of air quality regulations, which again, any layman can read and understand. That being the case, I'm not sure that my testimony is problematic.
All right. Thank you for that, Mr. Vigil. Do you have questions, or would you like to save them for cross?
Yes, I'll ask a couple questions. Mr. Block, how many air permitting actions have you worked on?
None.
None. Okay. Let's see here. Well, I guess that's it, and I will reserve my the rest for just running objections and then some questions on cross. Thank you, Mr. Block.
Okay.
All right, Mr. Block, go ahead and offer your testimony. Do you have the ability to share your
Well,
screen
I'm
at this time?
I'm trying to get it to share. Let's see here. I don't see it coming up. Let's go here. Can you see that?
Yes, sir.
So you have what you have in front of you here is a Google Earth image of the Mora Valley with the PG Enterprise facility here. My standing in this, in addition to my scientific background, is that I am part owner of the Mora Valley Ranch Supply, which is located over here, 1.3 miles downwind from the facility. And as I said, I'm really want to talk about dust. My concern is that the greater Mora community, which is located downwind from this facility, is going to be severely impacted by, as Mr. Chudnoff mentioned, fugitive dust from this facility. So, basically the residents, the people that work in this valley, even the school children, here's the Mora School District facility, spend a lot of time here. And anyone that lives and works in this community knows that it's already dusty, and that this facility will aggravate that situation. I want to make one comment on this photograph. You'll notice we've seen pictures of the valley to the west. It's a wide open valley and a very good wind tunnel. You can see there's a constriction here, and the valley opens up again to the east. This constriction is actually, in wind tunnel terminology, called a contraction, and you have high topography on either side. So the wind funnels through here, and wind contractions are built into wind tunnels to accelerate wind velocity. So that's going to aggravate whatever sort of fugitive dust generation there is from this facility. Let's go to the next slide. Okay, this is the notice that was posted that we've heard a lot about today. With respect to dust, I mean, Mr. Chudnoff talked about pollutants, primarily from the engine and equipment that's there. I want to focus on PM10, PM2.5, which is particulate matter 10 microns in size and particulate matter 2.5 microns in size. Those are relevant here because those are the size fractions that are define air quality standards according to the EPA. And the amount of material that's going to be generated by this facility is shown here, pounds per hour, about 3 for 10 and 0.63 for 2.5. And that equates to a little over 3.5 tons of material per year. Now, we've heard about that this facility may or may not be operating for a long period of time, but that's a significant amount of material. And in reference to Mr. Chudnoff, and I'm again mispronouncing his name, I believe, he discussed the fact that the crusher is just one part of this operation, and that's all that this pertains to. I've converted that to grams per hour because those are the units that the regulations specify. So here's some numbers. For the National Ambient Air Quality Standards for PM10 and PM2.5 are 150 micrograms and 35 micrograms, that's 1,000th of a gram, per meter cubed, respectively. So for every meter of material, air that flows by you, it can have that amount of material in it. That's an acceptable air quality. The amount of stuff that these guys are going to produce per hour is about 90,000 to 8,000 times the air quality standards. So it's a
Objection.
tremendous.
That's an objection. He's making a legal conclusion.
About how much it would exceed standards?
Yeah, the standards are written right here, and if you do the math,
we don't have a problem with him giving the information, but he's basically he's making the legal conclusion that his information is showing that the standards are exceeded. That's what I'm pointing out.
Okay, I think he's doing some straightforward math here.
And we would object to the inclusion of this page of his technical testimony.
Hold on, Mr. Block. And the basis for your objection?
Are you talking to me?
No, I'm talking to Mr. Vigil. The basis for your objection as to this page?
That it has a legal conclusion included in it.
Okay, so I disagree that it has a legal conclusion. And while we have interrupted you, Mr. Block, I need to confirm that I asked you if you swear or affirm that the testimony you're giving is the truth.
Yes, it is.
Okay, thank you. Please go ahead. And the objection is overruled, so please continue with your testimony.
Well, to finish my thought, this number, the amount of material that this refers only to the crusher, is generating is irrelevant if it all stays at the site of the crusher, which is considered a point source. And so it's not problematic as long as that material stays there. But as we have heard today, the anecdotal observations that we've heard from a number of people, the information from our previous witness, and a number of others, demonstrates that dust does escape from these facilities regularly. And so the question is, how much of this material is going to get out of this crushing facility? And how far can these total suspended particles, the TSPs, which is the total amount of material that the wind can lift off of this facility, how far can this stuff go? And unfortunately, we don't have a lot of detailed data from this facility. In fact, we have none. But things that affect all crushing facilities are shown here. And these are some of the things that are considered in modeling, doing the modeling of the transport of this material. You have the variable amount of material that's generated by various types of equipment, and we've heard a lot about that today. The point source or distributed source, and it's pretty obvious that we have both types of sources in this facility. The effectiveness of on-site mitigation efforts, which Mr. Chudnoff referred to, the water sprays. There are polymers and things you can add to waste piles to reduce dust emissions. Wind speed and direction is very important. And of course, we all know that the wind is blowing from the west to the east down the Mora Valley and potentially carrying material to the greater Mora business and residential community. The local topography, as I touched on in that initial slide, is very important. So that constriction has a profound effect on the ability, the competence of the wind to move material. The atmospheric moisture content, humidity and moisture reduce dust dispersion. And of course, we know we live in a dry climate. And of course, secondary source and dispersion effects, which have been touched on today. Truck traffic is a major one. Now, as I said, there is no direct data from this facility. There's no monitoring equipment. We know that there's dust in the air, and we know that there's dust coming from this facility based on anecdotal observations. So we have to turn to analogs to see if we can get some numbers about how much dust is being emitted. And this study is one that I found in the published literature. And again, anybody can get access to this stuff and read it. And it's not, again, I would argue with Mr. Vigil, it's not highly technical. What these guys did is they measured downwind dispersion of total suspended particulate matter from 6 facilities in Finland. These were all hard rock mining facilities that are very similar in terms of the equipment they use.
Objection. This is irrelevant and it's speculative. Applying a general study to a particular case, we object.
All right. Mr. Block, if you would move expeditiously through this insofar as it is not specific to the site in question.
Well,
please.
then I won't bore you with all the numbers. But this is very analogous to what we're talking about. The one thing I will point to is this table, which shows transport of very fine material very far away from the facility. And so I think the conclusions that you can apply to the Mora facility by looking at an analogous information that's out there is that large mass of fine particulates that are generated at this place are going to be dispersed and will likely violate our national ambient air quality standards. The fine material of PM 2.5, which I pointed out, will be obviously fine grained material is dispersed much greater distances than coarser material. And the PM 2.5, to put that in perspective, you need about 40 of those particles to equal the width of a human hair. These are very, very fine particles, and they can get very deep into lung tissue, and they are a great source of health problems that, that is a given. And it will provide, it will elevate, it will be an elevated health threat to the Mora community. And again, has been talked about quite a bit today. We already have a degraded landscape, which is contributing more fine particulate matter to the air. And the PG Enterprises facility is going to aggravate that post-fire burn scar. So that's basically all I have to say. I think the numbers that I glossed over demonstrate that the dispersion of this material is a real problem for the community. And without any monitoring data on this facility as a condition of approval, I really don't see how it can go forward. So I hope this information is useful to the board in making a determination. And that's all I have.
Thank you very much, Mr. Black. Ms. LaCruz Crawford, would you like to ask questions of Mr. Black?
Sorry. Mr. Black, just a couple simple questions. Have you ever provided any testimony before any administrative bodies or Congress or the legislature or in any other capacity regarding any air quality standards?
No.
And did you conduct any on-site assessments or assessments of the site outside of looking at articles that were just generally published?
No.
Okay, that's all I have. Thank you.
Thank you, Mr. Behill.
We have no questions. Thank you.
All right, Dr. Sinclair. Ms. Stanland. Mr. Maxwell. Thank you. We'll start with Member Garcia this time.
No questions. Thank you.
Member Honker.
No questions.
Vice Chair Trujillo.
No questions.
Member Ely.
I have no questions.
And on the platform, Member Bitzer.
Sorry, I was just trying to Google Mr. Block's academic background, but as limited as my own degrees are, I don't question his bona fides. He didn't mince. He went straight for the point and succinctly. I want to thank you for that, and very impressive.
Oh, Washington University is an excellent school. Thank you very much, Mr. Black. And any reason not to excuse Mr. Black? Oh, all right. Thank you very much.
Thank you.
Let's move then to Dr. Sinclair, I believe is the last of the petitioners who will be providing.
I still need a little technical help on getting my screen up.
Can I try and help? Okay.
So this is me.
Where's your documents?
That's it.
Okay.
All right, Dr. Sinclair, if you would state and spell your first and last name, please.
Dr. Fion, Ffion, Sinclair, Sinclair.
Do you swear or affirm that the testimony you're about to give will be the truth?
I do.
Thank you. Go ahead.
I just want to preface that I do bring some expertise to this. I have a PhD in multidisciplinary PhD in the sciences and the humanities, both in biology and in history. I have lived in Cleveland for 23 years. I have been involved. I'm trying to get the best place to sit for this. I've been involved in the fire restoration. I am intimately aware of the drainages and the entire environment of the eastern side of the Sangre de Cristos. First of all, I want to talk about the context of why we're here today. Do I have to put this further away? I mean, it's just, yeah, okay. As you know, we experienced a serious wildfire, the Hermit's Peak Taft Canyon fire in 2022, which has devastated the surrounding environment, caused a great deal of trauma throughout the community, and most critical to the issuance of this permit, has shaped new economic arrangements, widening the disparity of wealth between people due to FEMA payouts. The only reason why we are here today, is because of the HPCC fire and vast amounts of money going into a few hands throughout the community. Just because a company wants to come in and capitalize on this situation should not negate the fact that this is a rural, residential, water-rich, unique, historic, culturally intact, minority, underserved population where the trauma of the HPCC fire has already had a marked effect on the entire community. There are 4 primary points I wish to cover today. 1, deception is at play. I have a picture of the Cedar Rapids crusher up on the screen, and I will get to this.
Objection. This is argumentative and speculative.
I will get to this. Deception is at play. This is the 4th gravel crushing permit submitted for this location in just 9 months. 3 GCP2s, and now this new source review relocation permit. The site is adjacent to the historic village of Cleveland, and since the NSR permit was submitted, an annex has opened up on the other side of the Rio La Casa River, moving the facility closer into the village. Cleveland is not mentioned one single time in any of the 4 permit applications. Yet Cleveland has a zip code, a post office, a fire station, a playground, a mutual domestic water association, historic acequias dating back to 1852, is in a designated federal disaster zone, and has residences on the State Historic Registry.
Dr. Sinclair, keep it slow. You're doing well.
Okay, do I need to move further away? Further away? Slow down. Okay. Due to multiple public notices for GCP2s, and finally the NSR, the community was confused that there were different permits. This explains why NMED received a higher number of complaints regarding the GCP2 permits as compared to this NSR. The public notices had less and less meaning with each permit. Given that they were all posted in the same location on an 8x14 sheet of paper in 12-point font, there is no reason that people could discern that the notices were referring to different permits, especially as they were speeding by at 45 miles an hour. Additionally, the notice of public hearing was posted in the Cleveland Post Office and removed numerous times. Because there is no legal requirement to post the NMED notice behind locked glass, its removal means that many people in the community are still unaware that this appeal process is taking place today. The crusher that was brought onto the site in October is a Cedar Rapids CRC 1150S, with a capacity of 165 to 320 tons per hour. This is a larger capacity crusher than listed on the permit, both the original permit and the relocation permit. It is in excess of the 150 tons per hour limit stated in those permits. Since the permit has been approved, an annex has sprung up that extends the facility, increasing the area of operations across the Rio La Casa River, which now transects the site. The facility has been operational for months, with trucks constantly moving between the annex and the main site entrance. This adds additional road emissions, noise, traffic, and dust. There have been a number of red flag days recently, and clouds of dust have been seen blowing both from the facility and the annex. These red flag days are increasing in intensity with climate change factors in play. The closest neighboring residence to the annex is separated by just a wire fence. The annex contains stockpiles with numerous trucks staged and operating there. The effect this has had on the immediately adjacent neighbors includes increased dust, especially during high wind events, disturbance from early morning and late night maintenance crews, noise and fumes from trucks idling, and loud stereos blaring at all hours. Much of this activity is conducted outside of the permitted hours of operation, which in the winter are 8 a.m. to 4 p.m. and the summer 7 a.m. to 6 p.m. These misnomers echo inconsistencies throughout the supposed applicant's other required permits. For instance, the submitted Morrow County Environmental Impact Report makes no mention that this is an aggregate crushing facility and instead paints a rather bucolic picture of a fire restoration project. I say supposed applicant because the actual applicant, PG Enterprises, has not secured any of the required county or state permits for this facility, except this one, despite being the named applicant on this new source review permit. There is no required EPA stormwater pollution prevention plan or mining registrations under PG Enterprises for this location. I mention these things because it demonstrates malfeasance at play and the determination of El Rancho Escondido to get a permit by any means possible, including going through the back door with a relocation permit under the name of PG Enterprises as a means to get around the setback from nearby residences that was enforced in previous denials for a GCP2 permit. Number two, there is no responsible party. Who is the responsible party? The applicant has appeared in 4 forms over the months: Olivas Trucking, Oak Valley Excavating, El Rancho Escondido, and PG Enterprises. All these different entities, except PG Enterprises, are in some capacity connected to the facility location through family ties or shared equipment. The responsible party, PG Enterprises, the one with its name on the permit, is not present. The NSR relocation permit is in the name of PG Enterprises, yet the required mining safety permit
the New Mexico State Engineers Well Permit, the Historic Preservation Permit, the New Mexico Mining Permit, and the New Mexico Business Registration are all in El Rancho Escondido's name. The NSR permittee is PG Enterprises. Is PG Enterprises here today? Are they in the room?
Your question will have to remain rhetorical.
Okay. There has been no testimony entered into the record from PG Enterprises. But as the permittee, PG Enterprises has responsibilities written into this permit. As stated in the original permit, section B109, the permittee shall maintain records to assure and verify compliance with the terms and conditions of this permit and any other applicable requirements that became effective after the permit issuance. If the permittee is not present or operating the facility, how are they able to complete these tasks? The permittee is mentioned 116 times in the permit issued to PG Enterprises. Duty of care, which extends to federal agencies, is the legal principle requiring a person or entity to act responsibly to avoid causing harm to others. NMED has been negligent by issuing the NSR relocation permit to PG Enterprises, a company from Albuquerque who have never operated in Mora County, because as the responsible party, PG Enterprises does not and will not operate any of the facility and has no required federal, state, or county permits in its name to operate at the location permitted by NMED's action. NSR relocation permit RE 058661 is a ghost permit. PG Enterprise will not and is not involved in any capacity operating the site. El Rancho Escondido is the sole representative and operator. Number 3, the perimeter of operations has not been defined. Relocation of the PG Enterprises NSR permit from Rio Rancho is El Rancho Escondido's attempt to get around the setback issues that arose with their GCP2 permit applications that were rescinded. In all of the applications thus far submitted, there has only ever been one single GPS coordinate provided. There has never been corresponding GPS coordinates defining an area of operations or the plant. The original permit clearly states in section E, restriction on relocation, point 1, page A11, quote, the plant is defined as the perimeter of the area of operations, inclusive of all disturbed lands, including mining and overburden removal areas used for the job. This sentence establishes the boundaries and components of the plant. To break it down grammatically, the subject is the plant, the verb is defined, and the predicate is the perimeter of the operations. The second sentence in this paragraph is a conjunction. Quote, unless this permit authorizes a specific setback upon relocation, or unless site-specific modeling or modeling waiver is approved, approval of relocation shall be denied if the relocation falls with any of the following categories, A, B, C, D. This second sentence begins with a conjunction unless, and then introduces two conditional clauses that set the conditions and exceptions for relocating the plant. This second sentence does not negate the first sentence. Rather, it explains the rules for relocation of the plant. Put simply, the first sentence defines what the plant is, and the second sentence explains the conditions for relocating it. Part 2 of this section furthermore specifies how measurement is made, not from a single point, but rather, quote, distances are measured from the perimeter of the area of operations. The approval letter dated August 16th, 2024 sets out conditions for the plant and specifies in condition 7 any requirements for repositioning. The area of operations is mentioned 4 times in condition 7. Currently, there is a single latitude and longitude coordinate provided in the NSR application. It does not denote a perimeter of an area of operations, just a central specific point. It appears, but is not completely clear, and I think we've been talking about this a lot today because it isn't clear, but it appears, but is not completely clear, that the 67-meter setback in the NSR relocation permit is measured from the GPS point of reference provided in the application out from any plant engine. This vague definition does not provide a distance measurement between the perimeter of the area of operations and the restricted public access fence line as defined by the existing permit requirements of the relocation permit and the facility relocation requirements of the original permit. This permit is a required New Mexico state permit based on the requirements of federal law in the Clean Air Act. Yet it is not clear whether the setback in this permit, as written by Joseph Mashburn, is from any plant engine or from the nearest fence line. Without a perimeter of an area of operation, there is no possibility to measure an accurate setback. There is already a very large area of operations with disturbed lands, including mining and overburden removal areas. And as we have seen today, the edge of this area of operations is maybe 5 to 10 feet from the Acequia de Alto y Los Martinez. The restricted area for the facility, as required in Part B101 legal parameters of the original permit, is denoted by a barbed wire fence line around the boundary of the property. There is currently no signage, and with the annex in play, there is no viable restricted area because the Rio La Casa River transects between the main site and the annex has not been included in the restricted area. Trucks utilizing the restricted area are a mobile source of emissions not usually regulated under an NSR permit. However, these emissions from idling or on-site movement should be addressed in the permit because they contribute to accumulated fugitive emissions for the plant. Condition 4 and 5 of the final letter of approval are specific about dust control measures. And the stockpiles at the annex should be included as part of the plant because they are stationary sources of dust and emissions at the facility. The permit specifies what the dust control measures should be for the piles at the annex. But because the annex is not currently included within the area of operations or the restricted area, there is no dust suppression, despite condition 5 clearly stating that, quote, dust controls must be used on all equipment, traffic areas, haul roads, sites of overburden removal, active pile areas, and stockpiles. The annex is part of the plant and as such should be included within the restricted area. It also extends the area of operation and the restricted area and should be included in the permit as such. Part 4, my last part. The violations are more than bureaucratic. NMAC 20.2.72210B4 clearly gives authority to the Bureau to impose, quote, reasonable restrictions and limitations other than restrictions and limitations relating to emissions or emissions rates. The Bureau has chosen to ignore the critical fact that this is an important water-rich location. The current quarry is sited on a shallow aquifer where primary recharge takes place due to geologic drainage factors and the proximity of the Acequia de Alto y Los Martínez, the Rio La Casa River, the Rio La Casa and the Mora rivers. This not only endangers neighboring community and private wells, as shown in the submitted community hydrology report, but the integrity of the aquifer's recharge nodes, which are located directly in the vicinity of the mine site. Most of the already large disturbed area is within a FEMA flood zone. This is a 100-year flood zone, and in 1904, it flooded to the ridges and wiped out the entire valley. This is true. Given that we can predict that climate change is entirely unpredictable, we should assume it will flood again. The HPCC fire that decimated the region was a prescribed burn that went out of control due to Forest Service negligence. However, the reason it spread so rapidly and with such ferocity is because of climate change. There were unprecedented red flag winds for 18 consecutive days, which had never been previously recorded. After the fire, the monsoons brought flooding levels that had not been seen since 1904. It is not a matter of if flooding will happen again, but when. There is a large burn scar on and west of the property that goes up and over the ridge to the west. Any flooding and debris flows from this heavily burned area flow east and down toward the Mora and Rio La Casa rivers across the facility location. With the exposed ground, the aquifer is vulnerable to arsenic, phosphorus, nitrate, nitrite, and PFAS contamination. When westerly winds blow hard, the ash in this heavily burned zone can be seen in the air, contributing additional particulate matter to the dust that now blows off the site. We have had a number of extreme wind events in the last few months, and many in the community downwind of the facility have taken notice of the unusual amount of dust entering their homes. The residents of Mora County have suffered significant trauma due to the HPCC fire.
This trauma includes not only.
Objection, we've already covered this. We've already covered the trauma of the fire.
I'm just getting to my last point.
All right. Please make it
Okay. This trauma includes not only loss of property and natural landscape, but emotional and mental hardship. A federal judge recently ordered FEMA to pay fire victims for the emotional harm we have suffered. The loss of property and the loss of livelihood has created lasting detrimental, historic, cultural, and mental health impacts. The mining facility has been operating openly and illegally for months and has exacerbated these impacts, especially for residents in the village of Cleveland and the Cordillera, due to the industrialization, blowing dust, heavy machinery noise, traffic, and continued environmental destruction these conditions create. The continued loss of natural landscape and environmental integrity the quarry has created has caused further mental and emotional trauma to residents. The 2005 New Mexico Supreme Court ruling, Colonias versus Rhino, required NMED to consider cumulative environmental and social impacts in its rulings. The decision underscores the importance of environmental justice and procedural fairness in regulatory decisions, requiring agencies to account for public participation and the equitable treatment of affected communities when making environmental decisions. In assessing air quality standards, the exceptional conditions that pertain to the Cleveland location are again provided for within NMAC 20.2.3.108. Oops, wrong way. Quote, the adoption of these statewide ambient air quality standards does not prohibit the promulgation of standards for specific areas, functions, and conditions within the state, such as airsheds, municipalities, and certain counties as authorized under the Act. Given new parameters of climate change, the recent HPCC fire and ensuing floods, it would not only be folly to disrupt a vital natural cycle which has provided the people of Mora with clean air and drinking water, but it runs counter to the very regulatory mechanism you are employed to uphold. This is a matter of science. The effects of the wildfire, the ash from the severe burn, the historic flooding, together with the noise of the crusher, the screener, excavators and loaders, the dust, the increased traffic, alongside the substantial negative aesthetic effect and environmental degradation of an open pit mine in our rural community, has added continued emotional harm to the residents of Cleveland and the Cordillera. Approval of NSR Permit 8661 will take us backwards and does not consider the health, safety, and welfare of local residents. It not only destroys what we have left, but deepens the environmental destruction and emotional scars already inflicted by the HPCC fire. Please revoke NSR Permit 8661. It is the wrong location. The Olivas family has a location where they currently quarry. It is outside of the valley, in an appropriate location. They should be encouraged to relocate there. Thank you for your time.
Thank you, Dr. Sinclair. Let's take a short break and we'll come back to your questioning. It's been a while since we've had a proper break. We do have to be out of here by 5:30, though. Correct.
Out of here by 5:30.
So let's just take 7 minutes and come back at 10 of. Sorry, that's still short, but then we're only going 40 minutes after that. He gave public comment, Mr. Vigil. Okay, I still need to take a break. Let's come back from the break, please. All right. Ms. LaCruz Crawford, do you have questions of Dr. Sinclair?
I don't have any questions. Thank you.
Thank you, Mr. Behill.
No questions, thank you.
All right, Ms. Stanland.
You had mentioned the alluvial fan, and I'm wondering what is the research on that? What is the information that is defining that the quarry is in an alluvial fan?
Actually, I didn't mention alluvial fan, but I can explain that. The quarry is sitting at the apex of
Excuse me, you said recharge. And I assumed that alluvial fan and recharge node are the same. So
yeah, yeah. Okay, so where the facility is located is in the apex of an alluvial fan that comes out of that part of the eastern edge of the Sangre de Cristos. An alluvial fan is where that alluvial fan is underground. There's the aquifer. It's like fingers, and the pressure from the mountain at the apex of that alluvial fan is what pushes the water down into the aquifer. That makes any sense?
And what is the data that you have to back this up?
Well, actually, I have with the fire. I've been actually quite involved in the flood mitigation for the fire, so I have a lot of data. We have also been monitoring the level of the aquifer, and we did notice there was a drop. And they're also trying to figure out the relationship between the acequia and the aquifer. So the aquifer is actually recharged from both the acequia and the Rio La Casa rivers and obviously the Mora Valley. But the role the acequia Martinez plays in that recharge is actually quite significant. And the reason why we figured this out is because the acequia gets turned off during the flood events. And in that first year, it remained off for a number of months. And that's when we saw a drop of 10 feet in the aquifer.
And when you say we, who's we?
That would be Kate Ziegler from it's either New Mexico Geologic. I can't remember the name of her company, but she has been up in the Mora Valley since the fires, testing wells and monitoring the water table.
And is she working with the county also on trying to figure this out?
Actually, the county secured a grant in the first year after the fire for her to collect the data. That money has run out, and she is now securing further money through grants.
And when you say that this quarry is on top of a shallow aquifer, what is the data that you have to back it up?
None of this is relevant to whether or not the relocation was implemented or approved in accordance with the law.
I understand because
Ms. Stanley, it really is if any, attenuated relevance to the approval of relocation notice. How does this relate to the approval of the relocation notice?
the relocation doesn't include anything but air quality. That is the issue. That is the point that we are trying to make here today. And so does it have to do with it? No, it doesn't, because it doesn't have to do with air quality. But we are begging that it include the environment as a whole, not just air quality.
Okay, I understand that is your exhortation to the board. We've heard that, but I need to stop this line of questioning.
And thank you for the opportunity.
Thank you. Mr. Maxwell, do you have any questions of Dr. Sinclair? All right, thank you. Member Ely, any questions?
No questions.
Vice Chair Trujillo?
No questions.
Member Honker?
No questions.
Member Garcia?
No, thank you.
Member Bitzer?
No questions.
All right. Thank you very much, Dr. Sinclair.
Thank you.
Let's see. We will move. Let's see. Mr. Maxwell, did I ask you if you were going to make any statement or presentation? All right, thank you very much. I believe we have covered everyone else who entered an appearance or filed a statement of intent besides the department. Mr. V. Hill.
Thank you very much, Madam Chair, Madam Vice Chair, Madam Hearing Officer, members of the board. Let's see here. I guess I'll start by saying I'd like to move to enter NMED Exhibit 1 through 7 into the record if there's no objection from the parties.
All right, I heard from Ms. LaCruz Crawford earlier that the parties had agreed to stipulate to the admission of all exhibits.
Okay.
So yes, all exhibits are admitted.
Thank you so much. And if it's agreeable to everyone involved, what we will do is we will provide our direct and rebuttal for each of our witnesses, for each of the department's technical witnesses, and they can, if it's agreeable, they can sit as a panel and take questions together if there's no objection to that, and then Mr. Olivas, can do his direct testimony and take cross-examination individually. Is that acceptable?
All right. You may know that I favor panels of department staff, for example. And so let me get their names, swear them in, and where are they going to sit in order to, let's see, Ms. LaCruz Crawford, could you move from there? I'm sorry. Okay. Wait for her to move aside. There you go. Gentlemen, if you would come up on the dais, please. Mr. Peterson and Mr. Mashburn, right? All right. Mr. Mashburn, would you please state and spell your name for the record?
Yes, JOSEPHMESHBURN.
Thank you. Do you swear or affirm that the testimony you're about to give will be the truth?
Yes.
Mr. Peters, same request.
Eric Peters, ERICPETERS.
Do you swear or affirm that the testimony you're about to give will be the truth?
I do.
Thank you. Go ahead, Mr. V. Hill.
We'll start with Mr. Mashburn. Please state your name for the record.
Just did.
Joseph Mashburn.
I have a script here. Where are you currently employed?
I'm employed by the Air Quality Bureau of the New Mexico Environment Department.
And what is your job title?
I'm a permit specialist in the Minor Source Permitting Unit of the Air Quality Bureau.
And what are your job responsibilities as a permit specialist?
I review air quality permit applications for administrative and technical completeness and accuracy. I also coordinate with various stakeholders, including the public, industry, consultants, other air agencies across the nation, and internal colleagues here at the Air Quality Bureau. If a proposed facility meets air quality regulations and standards, I write a legally enforceable permit that specifies all state and federal regulations, as well as the emission limits that apply to the facility.
How long have you worked in the permitting section?
I've worked in the permitting section since October 2016.
And in your time with the Bureau, how many permitting actions have you worked on?
I've worked on over 640 permit actions.
640?
Yes, sir.
Okay, thank you. Could you briefly describe your educational background?
I have a Bachelor of Science degree in biology from University of Central Oklahoma and a Master's of Business Administration from the University of Oklahoma.
And I want to direct your attention to NMED Exhibit 1. Is this a copy of your latest resume?
Yes.
And did you submit pre-filed technical testimony for this hearing?
Yes, it is NMED Exhibit 2.
Do you have any corrections or additions to your written technical testimony you'd like to make at this time?
No.
And do you accept your written testimony in its entirety?
Yes.
Okay. Can you provide us a brief overview of your testimony?
Yes, my technical testimony presents my qualifications, a summary of the PG Enterprises relocation application for NSR RE05 8661. It has an overview of construction permits authorized under 20.2.72 NMAC, which stands for New Mexico Administrative Code. And it also has the specific exemption category for NSR portable source relocation under 20.2.72.202.D NMAC. And it also has a summary of my review of the relocation application for NSR RE05 8661. In my testimony, I described the administrative review, which is an initial review that confirms all the required parts of the application are present. I also described a technical regulatory review, which involves verifying which federal and state regulations apply to the facility. And in this particular relocation, I reviewed requirements in the underlying portable NSR 8661, which the applicant wanted to relocate. My testimony also summarizes the Air Quality Bureau's public outreach efforts throughout various stages of this permit relocation action.
What was your role in the Air Quality Bureau's review of PG Enterprises relocation application for NSR RE05 8661?
I'm the permit specialist responsible for completing the administrative and technical review of relocation application NSR RE05 8661. I'm the primary contact for citizens, along with other permitting staff members, of course, who would call with questions or submit comments pertaining to this application. Early in the processing of the application, the department on August 8, 2024, posted a copy of the application for the relocation on the Air Quality Bureau's webpage for public notices. The department then on August 9, 2024, also posted the revised application on the same webpage. Since then, I've continued to provide updates on that webpage as more information became available. I also responded to citizen calls. I read all of the written comment letters. I've worked with PG Enterprises and their consultant for the NSR RE05 8661 facility to obtain necessary updates for this application. I wrote the relocation approval letter and I sent that out in accordance with the regulatory requirements. I also wrote the underlying original NSR 8661 portable permit, which is the basis for this relocation. I also compiled the administrative record index, and my written testimony for this public hearing on the relocation application.
What is the function of an air quality construction permit?
An air quality construction permit places restrictions on what construction is allowed, what air emission limits must be met, and how a facility can be operated. A permit is an enforceable legal document that a facility must comply with. To ensure that a facility complies with a permit's emission limits, a permit contains monitoring, record keeping, reporting, and testing requirements. In this particular case, if the Air Quality Bureau staff determines upon reviewing a relocation permit application and the underlying NSR portable permit that a facility will not meet the requirements of air quality regulations and standards, and NSR relocation will not be issued.
Can you describe how the department gave formal notice of this hearing as required by the regulations?
Yes, AQB staff drafted the notice of hearing in English, arranged for the notice to be translated in Spanish, and provided the notices of hearing to the Environmental Improvement Board, EIB, for docketing on November 6, 2024. Then the Bureau distributed notices in accordance with the regulatory requirements in the new New Mexico Administrative Code 20.1.2.205 NMAC. And I should point out, this is because it's the hearing before the EIB. So it falls under 20.1.2.205. Also on November 6, 2024, the notices of hearing in English and Spanish were added to the Bureau's public notice webpage. The department posted the notices on the department's events calendar website on November 13, 2024. I printed hard copies of the notices in English and Spanish to be mailed by postal service to citizens who had submitted written comments only by postal service deliveries. I then mailed the notices in English and Spanish to the North Central New Mexico Economic Development District. This was to notify the Mora land grant. Also on November 13, 2024, I sent out emails with notices of hearing in English and Spanish to citizens who had expressed interest in the relocation application. I sent it to PG Enterprises and the consultant. I sent it to EPA Region 6, Mary Layton with EPA, Eric Ledoux with EPA. And then on November 15, 2024, I sent out emails with notice of hearing in English and Spanish to the petitioners who were also interested citizens. To satisfy 20.1.2.205A1 NMAC, the notices of hearing in English and in Spanish were published in both the Las Vegas Optic and the Albuquerque Journal on November 15, 2024. On November 16, 2024, the department posted notices of hearing in English and Spanish on the bulletin board of the Cleveland, New Mexico Post Office. The department also arranged for the notices of hearing in English and Spanish to be published in edition number 123 of La Voz de Mora, a Cleveland, New Mexico publication, on November 25, 2024.
What's the purpose of the relocation permit application submitted by PG Enterprise for the Mora County facility?
A relocation application submitted by PG Enterprises for air quality permit number RE058661. This allows PG Enterprises to relocate their PG Rio Rancho facility New Source Review Portable Permit 8661 to operate an aggregate processing facility near Cleveland, Mora County, New Mexico.
What is the Air Quality Bureau's role in regulating issues such as noise, county zoning, or county regulations, FEMA floodplain zones, proximity to the river, impact on surface or groundwater quality, impact on nearby acequias, impact on public roadways, impact on quality of life, water conservation, and property values?
The Clean Air Act and state regulations are health-based regulations. They do not provide the Air Quality Bureau legal authority to regulate impacts that are not specifically related to air quality. Primary national ambient air quality standards provide public health protection, secondary national ambient air quality standards, provide public welfare protection, including protection against decreased visibility, damage to animals, damage to crops, damage to vegetation, and damage to buildings. The Air Quality Bureau cannot deny any applicant an air quality permit based on issues such as noise, odor, water usage, truck traffic on public roads, any county zoning or county regulations, as in Water County, and impacts to property values.
How would the relocated permit ensure that emissions from the proposed facility do not exceed the levels represented in the application and application updates?
First, the applicant for a portable NSR permit relocation is required to operate the facility as represented in the application updates, and the underlying NSR permit. The failure to operate the facility as represented in the application or in the application updates and in the NSR permit would be considered a violation of the permit and would be referred to the enforcement section of the Air Quality Bureau. Second, the permit contains requirements, monitoring, record keeping, and reporting conditions to ensure ongoing compliance with the emission rates in the permit.
Can you describe how PG Enterprises air quality permit RE 058661 for the Rio Rancho facility meets all the applicable regulatory requirements?
Yes, the facility as represented in the application, which is so important, and the underlying NSR permit 8661 demonstrates it can operate in compliance with all relevant federal and state air quality regulations. In New Mexico, construction permits are required by 20.2.72 NMAC for facilities with a potential emission rate greater than 10 pounds per hour or 25 tons per year of any pollutant with a national or New Mexico ambient air quality standard. PG Enterprises application RE058661 meets the requirements of 20.2.72 NMAC. Specifically, it meets the exemption requirements under 20.2.72.202.D1 and D3 NMAC. I need to underscore that this application for relocation, it falls under exemption requirements in the Part 72.
Does the Air Quality Bureau have any proposed amendments in the relocation approval letter?
I apologize. I was going to finish up by saying.
I'm sorry. Go ahead, please do.
I was going to say none of the listed basis for denial of a facility relocation, none of those listed bases exist under NSR 8661 permit condition A114 for facility relocation requirements. Compliance with all applicable state and federal air quality regulations will be demonstrated by following requirements specified in the permit conditions.
And does the Bureau have any proposed amendments to the relocation approval letter?
Yes, the Bureau proposes to amend RE058661 by adding condition 9. Condition 9 states, the facility shall not operate during the time of acequia maintenance or improvements that occur within the property the facility is located on, and Eric Peters will give testimony on this proposed amendment.
And before we get to Mr. Peters' testimony on that, that would include the operation of trucks?
Facility operations as under the existing permit. It does cover trucks and on
So truck traffic, in other
trip-
words,
yeah,
truck
it
traffic
covers-
would have to
it
stop.
covers truck traffic
Yes.
on the hallways. The permit does not cover mobile source emissions, as in emissions from semi-truck. That the permit does not address.
Okay. Okay, thank you.
Anyway, sorry.
What is the Air Quality Bureau's recommendation regarding the issued NSR, the approved relocation letter? The amended relocation letter.
The Air Quality Bureau recommends that the Environmental Improvement Board uphold issuance of NSR REO5 8661 as amended.
Okay, then we'll move on to a live rebuttal if there's no objection. Ms. Jones, could you bring up Bates number 0036 from the administrative record? Thank you.
Madam Hearing Officer,
Ms. Cruz Crawford.
sorry to interrupt. Can you explain, so with this paneling, this is new to me, so I just want to be clear that I understand how this proceeds. Is it that questions can be posed to either of the two witnesses or they're just, okay. Thank you.
It's actually meant to make it easier, particularly for non-lawyers, to examine department staff because they don't have to figure out the precise contours of the scope of each staff person.
Excellent, thank you.
Go ahead, Mr. Viham.
Thank you so much. Mr. Martinez testified that the public or the notice of the facility notice in this matter was posted on a tree. Can you respond to that assertion?
The photographs provided in the relocation application by PG Enterprises, it shows that the public notice was posted on a fence.
I might have given you the wrong page, Ms. Jones. Could you scroll over the next couple images? There's a few images of the actual notice that was posted. Yes, and could you, is that the notice that Mr. Martinez was talking about?
This is the notice, but this notice was posted on a fence rail.
Okay. Can we go to the next image, please?
And it was certified by certification statement by Naomi Montoya that it was posted on July 27.
Okay, thank you so much. And in this image, the notice of application is not posted on a tree. It's posted on a signboard at the fence line, correct?
That is correct.
Okay, thank you so much.
That is the public notice.
On page 2 of Exhibit 10 of the petitioner's statement of intent, Mr. Chudnoff raises the permitted daily process rates versus the daily production rate represented by PG Enterprises to the New Mexico Mining and Natural Resources Department. He states, quote, PGE is authorized to process up to 1,200 tons of material per day under its permit. This is 4 times the daily production rate disclosed to the New Mexico Mining and Natural Resources Department. Can you respond to this issue?
The permit 8661, the underlying permit, which was relocated, it authorizes a daily average hourly production rate not to exceed 150 tons per hour with allowed daily hours of operation based on the month of the year, kind of the season that it's operating. Daily authorized production rates in the permit, they're not limited by any representation that PGE made to the New Mexico Mining and Natural Resources.
On pages 2 and 3 of Exhibit 10 of the petitioner's statement of intent, in item 3, Mr. Chudnoff makes various assertions to support his opinion that the relocation is co-located with an unpermitted operation. He states, quote, Section 2 of the relocation application asks whether the proposed facility will co-locate with sources, other operations, as allowed by permit relocation 8661. PG Enterprises answered in the affirmative and provided no answer to follow-up requests by the department to identify the authorization, permit number, and condition number. PGE was required to locate the area of operations of the co-located facilities on the ground maps to be submitted with their relocation application. Can you speak to this assertion?
Yes, in my experience, this is not a correct interpretation of the applicant's response here under Section 3, line 3. And if you wanted to refer to the administrative record, Bates, page 024, line 3 does ask that question. It does ask, will this facility co-locate only with sources as allowed by one of the applicable permits for the facilities that are co-located at the new site? Then it says, if so, provide the authorization, as in the permit number, condition number. I want to point out, just because the applicant answers yes, this does not mean that there are currently other authorized co-located permitted facilities at this site. The applicant is only saying, if we're going to co-locate with a facility, it'll be a permit facility. That's a if. They are not co-locating with any permitted facilities at the site. This might be kind of an artifact in the questions on that form that we could modify,
Mr.
to make
Vigil?
it more
I'm
clear.
very sorry.
Yep.
I need to interrupt questioning. We actually do need to leave the room very soon.
Yes.
And some people need a little more time to pack up their laptops, for example. I'm wondering, next Friday is the board's usual date for its regular January meeting. So I believe the board members have next Friday available. That's January 24th. I'm wondering, you're shaking your head.
Yeah, I'm actually I'm not gonna be in town that day, unfortunately.
Okay. Would you be able to do it virtually?
No,
No.
I'll be driving.
All right. Let me ask, then I'll do it the way I usually do it. What about the 21st? That's next Tuesday.
Yeah, we can do the 21st.
All right. Now let me ask Ms. LaCruz Crawford. What? So I need to consult with the board members and everybody if it would help to not start at 9 a.m. I can. Okay. Sorry. Oh, you want to stick to Fridays? Okay. Sorry, Vice Chair Trujillo asking me to stick to Fridays. What about Friday, January 31st? Okay, so I have a yes from Member Ely, yes from Vice Chair Trujillo, a yes, but not for Member Garcia. Okay. I'm going to keep stepping through Fridays. February 7th. No, to Ms. Ely. February 14th, y'all can be each other's Valentines. Yes, 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 yes. Terrific. Mr. Maxwell, Member Bitzer. Great. Great. Yay. All right. So we will be finishing up the evidentiary record on February 14th. Yes.
Yes.
Okay. Any reason we can't start at 9? Okay. Now, as to a location, let me just offer the place we're going to try to go, so we won't be here, is Porter Hall, which is in the Wendell Chino building over on St. Francis. That's going to be our first attempt. Then we'll look to maybe the Runnels Auditorium, but basically we're going to be looking at the auditoriums of other state buildings. Okay, it will not be here. It's the session. All right. We will pick up where you left off. Please make a note because we don't want to be repeating things. Ms. Stanland. I'm sorry? Yes, February 14th at 9 a.m. And we will notify you when we have confirmed a location, but it will be another state building somewhere in Santa Fe. Okay, anything else? I am going to ask Pam to distribute a case. I've heard the Rhino case cited several times, but not the Court of Appeals case much more recently that considered whether Rhino applies to air quality permitting. There is such a case. So I'm going to distribute that to anyone who wants a copy. And you can reflect on it before we gather again. Anything else at all before we adjourn for the day and with a plan to reconvene on February 14th? Oh, okay. Thank you all very much. Safe drive home.
Okay, so I need to do an adjournment, an official adjournment, I believe.
Yes.
So moved.
Do you have to?
I think so, yeah.
Okay, well, I'll say.
Okay, I've got a motion to adjourn. Do I get a second?
Second.
Great,
Unless
thank you.
that was my motion.
Member Garcia, can I get a roll call vote on that?
Sorry, okay.
Aye. Aye.
Can I have the motion for who made the motion in second?
Member Bitzer made the motion for adjournment. Member Garcia made the second.
Okay. Member Bitzer, how do you vote?
I vote yes.
Okay. Member Garcia.
Yes.
Member Honker.
Yes.
Member Ely.
Yes.
Vice Chair Trujillo.
Yes.
And the motion passes and we're adjourned.
Thanks, Pam.